On the record in the matter of the people of the state of Michigan versus Damon Bisbee. Is Mr. Etheridge in here? I don't see your attorney. We'll call your case in just a moment. On the record in the matter of the people of the state of Michigan versus Cody Clower, file number 23-01846, counsel appearance.
Good morning, Your Honor. Nathan Kellis on behalf of Mr. Clower, who is present today via Zoom.
Mr. Clower, can you hear us? Mr. Clower, you're muted.
Yes, Your Honor.
Okay, thank you. Today's the date and the time that's set for sentencing. I have a pre-sentence report and recommendation. It was prepared back on October 16, 2023. Mr. Collison, did you get a copy of that and did you review that with your client?
Yes, Your Honor. We received a copy via email. I transmitted it to my client. We discussed it yesterday and find no additions, corrections, or deletions.
Okay, very good. Did you want to make allocution at this time?
Yes, Your Honor. Just briefly, I think that the assessment pretty much sums up the situation here. Mr. Clower stands before the court in a situation that he hasn't found himself in quite some time. You note that his record reflects no association with the criminal justice system for quite a while. He's both remorseful and ashamed that he has to appear in front of the court in this capacity. He's assured me that this is an isolated incident, not reflective of his character or personality. I would also note that the overall impression by the interviewer was that in the assessment here for Mr. Clower was moderate to low. I'd like the court to take that into account when sentencing him. I know that there's a recommendation for a year probation with the granting of 7411 status. I'd ask the court to consider a term of probation of 6 months, also granting him the 7411 status. I think he'll be a good candidate on probation. I think that the outlook for successful completion is pretty positive for Mr. Clower.
Did Mr. Clower wish to make his own statement today?
No, thank you, Your Honor.
Okay. I reviewed the pre-sentence report and the recommendation. I've also reviewed, Mr. Clower, your prior criminal history. Although this is the first drug-related conviction that I see, I do see multiple convictions that involved driving under the influence, which indicates to me that there's some underlying issue that needs to be addressed. The impressions from the probation department were that you would benefit or be a good candidate for 7411 status. I think that although they have not recommended any treatment at this point, other than a 12-step meeting, that we would benefit from having you on a term of probation to monitor you by having random drug testing and your analysis testing so that if there is an underlying issue, it can be properly detected and it can be addressed. And so based on what I see here in your prior criminal history, plus this incident here, I think it's appropriate to have him placed on a term of 12 months probation. I'm going to adopt the recommendation without any changes. The 7411 status will be granted. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess firearms, ammunition, or weapons of any kind. You're not to use, purchase, or possess alcohol, drugs, or marijuana unless you have a valid prescription. Do you understand that?
Yes, Your Honor.
Okay. You will be required to submit to random preliminary breath testing and or your analysis testing. You're responsible for the costs associated with that. You're not to be at any bars or nightclubs while you're on probation. I'm going to order that you attend a 12-step program as verify it with your probation officer, but you'll do it as directed by probation at this time. So I'm not going to order any specific times that you need to do it per week. They'll discuss that with your probation officer, okay?
Okay.
And you're currently employed full-time at odd jobs. How's that work?
I do like maintenance and restorations.
And you're doing that 40 hours a week?
Yes.
Oh. But you're doing it as an independent contractor, is that accurate?
Yes, Your Honor.
Is it seasonal or all year long?
Mostly seasonal. I was gonna obtain a different job. I was just waiting to see what my requirements were for this. I didn't want to start something and then not be able to complete it because I had to do stuff for probation or the courts.
One of your requirements is that you obtain and maintain employment throughout your probation status. So you'll be required to provide verification of that to probation, okay?
Okay.
While on probation, there is a $30 per month oversight fee that you're responsible for. It's a $75 crime victim rights fee per statute, which must be assessed. There's a $50 state minimum cost that also must be assessed. I'll waive discretionary fines and costs at this time, so your total fines and costs will be $485, okay?
Yes, Your Honor.
And you'll be expected to make monthly payments on that. Do you have any questions about your fines and costs or your probation at this time?
No, Your Honor.
Okay. Lastly, I have an advice of rights as to probation. It states you have been placed in a term of probation before the 54A District Court. Their terms and conditions have been individually tailored and are specific to address your assessed risks and needs, except for domestic violence, criminal sex crimes, stalking offenses, or an offense where the defense of guilty but mentally ill was asserted. You may be eligible for early discharge from probation. You would have the following rights. You have the right to request early discharge from probation once you complete half of the original term ordered by the judge. Your probation officer may, but is not required to, file a notice with the judge once you become eligible for early discharge. They would serve a copy of that notice on the prosecuting attorney. The prosecuting attorney would have 14 days from receipt of that notice to file written objections to your early discharge. You may make your own request once you have completed half the original term, so in this case, 6 months, so long as you have completed all of your probation requirements and you have not had any violations within the 3 months preceding that request. You would send a copy of your request for early discharge to both probation and the prosecuting attorney. The prosecuting attorney has 14 days from receipt of that request to file any written objection to early discharge. If I set the matter for a hearing to address your matter for early discharge, you have the right to hire an attorney. You would not have the right to court-appointed counsel for that purpose. Lastly, you can get that form to make the request off the court website. It's called the MC 512 form, or you can get it from your probation officer, okay?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Okay. Counsel, any additional matters for the record today?
Not at this time, Judge.
Okay, Mr. Clower, I need you to check in with our probation officer or our probation department no later than Monday so that they can make sure they have accurate contact information for you so they can go over this judgment of sentence with you, okay?
Yes, Your Honor.
You're all set. Thank you.
Thank you, Judge.
Thank you. On the record in the matter of the people of the state of Michigan versus Edward William Foss, file number 23-02467. Council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott, representing Mr. Faust, who's standing to my right.
Mr. Kraus, today's the date and time set for sentencing. I do have a file here, but let me see what it is.
I have a copy, Your Honor, if you'd like.
I need my own copy. I will block the record. Is that your copy or you have another copy?
That's mine, but you're welcome to it, Your Honor. I read it already.
Yeah, there should have been one in my file. Who prepared this? Editor Hosty. Make me a copy of this, please. I'll copy this in just a moment. We're off the record.
Yeah. While we're off the record, I just want to let you know the victim is here and she would like to address the no contact order. If there is.
Sounds good. Are they gonna bring it to? Lord mercy. Yeah, I see his form in here, his questionnaire and everything else. I just don't have those first 2 pages. Sorry?
Well,
It's been a couple of years. Sorry? What's in there? That's not in there either. No. Okay, back on the record, in the matter involving Mr. Faust. I now have 2 of the missing pages of the pre-sentence report. I'll get the 3rd in just a moment. You received this report, Mr. Abbott, and do we need to make updates, corrections, or deletions?
no, Mr. Faust and I reviewed it and have no additions, deletions, or corrections.
Okay, you can make allocution at this time.
Thank you, Your Honor. As the report indicates, Mr. Faust takes responsibility for what happened there. He recognizes he has a drinking problem. And he is very much interested in addressing that and addressing the way his relationship with the victim here. He has the court to go along with the recommendations. He's confident he can complete programming and successfully complete probation. Thank you.
Client want to make a statement?
Yes, Your Honor, the victim would like to, I'm not sure, I have not seen the PSI, I'm not sure if there's a no contact recommendation. I know typically in these cases there is though. And so the victim would like to address the no contact if there is one, Your Honor.
You can make her statement. Let's go. Yes. That's this thing, it's not cross. Did Mr. Abbott get a correct copy or did they mix it up in probation?
It's got to be mixed up because the one he gave me says Felony.
Did you get this in an email?
Oh, it's what?
Did they probation email?
Oh, they just bring
So where's our?
And what is right here, yeah, is what they give us.
We don't have one.
Parts of what you just gave me are not using funds.
Is Kavadowski here? Yes, we need somebody upstairs at this point. Well, you didn't get a complete pre-sentence report either then.
Well, Your Honor, I've just been handed a document about possession of methamphetamine. It's not my part.
Right, I think, but even what he has is not in our file. He had these in his, we didn't even have that in ours. So I'm gonna go off the record, so this could be cleared up and I'll move on. That should have been checked before today anyways. Which means this is probably, who's representing Mr. Bisbee? Ma'am, could you have a seat? I'm gonna have to call the case back once they fix the report. Who's Mr. Bisbee's? Oh, we don't know where Mr. Etheridge is.
she's not doing that, so.
Okay, on the record in the matter. People of the state of Michigan versus Cody McInnes, file number 23-02612. Council Chambers.
Jeff Radowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Richard James on behalf of Cody McInnes, who's approaching or be standing to my right.
Oh, today was the date and the time that was set for a preliminary examination. However, there's also, I'm sorry, a probable cause conference. However, we now have a PA 53 contempt, which I have revoked your bond. Do you know why?
Yes,
Why?
I didn't call on the reported day I was supposed to call and check in.
According to pretrial services, on August 25th, you were arraigned and you was enrolled with pretrial services. You were supposed to check in, and it says on 9/1/21, you failed to appear for your probable cause conference. 9/8, the defendant was arraigned and issued a personal bond. 9/28, you failed to call him for scheduled check-in. 9/29, reporting investigator attempted to contact the defendant for his missed check-in voicemail, left the voicemail for callback, no call was received. 10/9/2023, 10 days later, reporting investigator attempted again to contact the defendant for his missed check-in. Voicemail was left for a callback, no call was received. Why not?
To be honest, ma'am, I just totally missed. I forgot at the same time. I thought I did check in, but I checked in on the wrong day or something of that nature because.
It is nowhere on there that said you ever checked in.
No, I'm saying like I went to jail twice, and it kind of threw me off when I went to jail twice. So I'm sorry I didn't check in. As soon as I was alerted that I didn't check in, I called and turned myself in immediately because I wasn't trying to run. I just.
When did you check in? What day?
I would have to look at my
Was
phone.
it this week?
Last week.
Your Honor, if I may, it was right when we received the violation. I texted him and I believe he immediately checked in. Just to add a little bit of context, he missed his pre-trial, his PCC on 9/1. He said when he woke, his phone services were off, so he couldn't get on Zoom. He went and paid the bill, had them restored. He tried to reach out to his public defender. He was unable to reach them. He then contacted me over the weekend. That was Labor Day weekend, and he did retain our services. I immediately reached out to your staff by email asking how Your Honor would like to handle the bench warrant status. And then I was informed that he would have to go through the magistrate and turn himself in because it was a felony charge. He immediately did that the next day that was available, which was that Friday on the 8th. And again, he was rearranged. And I think that's where some confusion set in for him as far as him checking in no way trying to minimize or downplay this on his behalf, but just to shed some light and inform the court that I don't think it's deliberate on his part. As soon, again, as we received the bond violation that he did not check in, I informed him, he immediately did it. This case was also set for a PCC on 9/21. And at that time, our office was in a homicide trial. We asked for a stip to adjourn, but if I remind the court, Mr. McKinnon showed up on Zoom and remained there for that PCC until the court did dismiss him because we submitted the stip kind of late the day prior. So we didn't receive it timely. I informed him he will have to remain there until you hear different. And he did hear that it would be adjourned. So again, I don't think it's intentional on his part, but I have explained to him that you are an adult and you need to be more diligent and responsible about your own affairs. Put the dates in your phone, have a backup if your phone gets cut off. It's just not acceptable. But I do think that we've discussed this and I've drilled it in him and I don't anticipate any other issues going forward. And I would respectfully ask Your Honor to consider reinstating his bond.
First issue, and thank you for that. First issue I have is the reason you gave as to why he missed his court date on the first is completely different from what he told the magistrate.
I was at that arraignment and he did say that his services were off.
Defendant said I was at work and I forgot.
Your Honor,
That's what she wrote in here as why he missed
also
court.
said his services were off. But that's even when he called me to retain, that's what he explained. He said my services were terminated because I did not pay my bill. He said when I went to pay, I tried to call my public defender. I couldn't get them, then he contacted our office over that weekend.
Okay, so he was adjourned originally on this, I think, August 21st. Is that accurate?
Yeah, he was originally arraigned August 21st, yes. And he did reach out to pretrial August 25th, and he was informed, and he has indicated to me that he was told that he has to check in monthly. But I think turning himself in, being rearrested and rearranged, set in some confusion for him. And again, I told him that's not acceptable. You're an adult, you have to do better. Correct.
I don't know how it sets in confusion. That it should have reinforced anything. It's because you would have been told twice that you got to check in with pretrial services. That's standard. You have to check in, and you check in monthly, unless we say weekly. You understand that? I'll dismiss the violations and reinstate your bond. Okay, and as to the probable cause conference, how are we proceeding?
Your Honor, I have had a chance to discuss it with the prosecutor, and I think at this time we're in agreement to leave it set for the exam. And if I come to a decision that we're not going to run an exam, of course, I will reach out to him at the court time.
Okay, so the exam is scheduled in person at the court November 9th at 8:30, correct?
Yes.
Okay. Do you have any questions about your bonds at this time, sir?
When do I gotta check in, call and check in again?
You have to check in monthly. I don't know what that date is. You need to call pretrial services and find out.
It's still the same date as.
Call him today and clear it up and write it down. So there's no more confusion going forward, okay? Okay. So take call today. Next time you can be sitting here.
Just briefly for the record, Your Honor, just there was no offer from the people at this time. However, in district court, I should say in district court, however, negotiations could continue in circuit court.
Sounds good. Any additional matters for the record?
No, thank you, Your Honor.
Nothing from the people, Your Honor.
Thank you. You're all set. We still have Mr. Etheridge.
Mr. Etheridge is on the record in Judge Flores' authority.
Okay. Mr. Abbott, you were waiting for, I think all the rest of your people are in custody.
Yes.
Okay, I'm not sure what time they're gonna get here today. Okay, sounds good. And then Ms. Smulders, which matter are you here for?
Stephen Williams, Your Honor.
Record in the matter of the people of the state of Michigan versus Stephen Williams, file number 23-00434 FY, counsel appearance.
Valerie Smulders on behalf of Stephen Williams, who is also appearing via Zoom.
Today's the date and the time that's set for sentencing. We have a pre-sentence report here. It was prepared back on October 11th, 2023. Did you get a copy of that report, Attorney Smulders?
Yes, I did, Your Honor, and that was forwarded to my client. And it is correct. There are no additions, corrections, or deletions that are needed on that.
You can make allocution.
Sure, Your Honor. So my client is requesting, and of course we are as well, that the court is lenient when it comes to sentencing on this matter, and that the court would honor the plea agreement with a recommendation of no jail time. I did want to note for the court that my client took it upon himself at the first initial meeting with our office to request any services that he could have, such as anger management, etc., in order to get himself out of the situation in terms symptoms of the emotions that he's been dealing with, and try to get himself on the right track. He initiated the request for all of these self-help services, to which we obviously gave him information and to kind of go about on his own accord. As you know, in the PSI, you know, my client had somewhat of a difficult childhood growing up, and he's still fairly young in life himself. He has made concerted efforts to kind of refrain from hanging out with any of the people in his past, including the people that were surrounding him during this incident. So we just request that the court be lenient when it comes to sentencing and honor the recommendation at the plea offer agreement. Thank you, Your Honor.
Currently still in warrant status?
I'm sorry, what was that, Your Honor?
Does he still have pending warrants? Because my report indicates that he had a warrant in 74B District Court for a assault and 2 counts of assault and battery, and that he had a warrant in 76th District Court for police officer assault causing injury, police officer assault resisting obstructing, police officer assault resisting obstructing.
So I looked at my associate's notes regarding this matter because typically Ms. Korndike is here. She had indicated that they recently became aware of those warrants through the PSI, and she had instructed our client to go take care of those warrants.
Did you go take care of the warrants, Mr. Williams? You're muted.
Your Honor, as soon as this matter is resolved, I planned on taking care of those warrants immediately and speaking with my attorney as well through those.
Okay. And so the pre-sentence report, and I don't know, I want to give you an opportunity if you wanted on your own, Mr. Williams, to address the court before I sentence you. Did you want to make your own statement?
Yes, Your Honor. I'm just I am attempting everything I can to get out of the situation that I was put in. It was a very bad day for me that all this had happened. I have taken all the steps that I have needed to further my actions on being successful and not doing any negative things to impact my future. I understand that these are serious matters and that I have taken the actions to fix them.
When you say that you were put in a situation, how were you put in a situation?
I had put myself in a negative situation based on rational decisions that I have realized that are not appropriate. And I've been taking the steps to become better.
Thank you for clarifying that. I reviewed your pre-sentence report and the recommendation. Pre-sentence report indicates, amongst the fact that you have warrants pending on 5 counts in 2 separate courts, and a detainer, it says, for pending charges out of the 30th Circuit Court. It also indicates that you scored high in the neighborhood problems and personality characteristics domain. It says that you scored moderately high in the family IP relationships, companions, and attitude behavior domain, and you scored moderately low in employment responsivity domain. More importantly, the officer that you met with and the one that drafted this report indicated which was relevant information, and that was evident by a review of your criminal history, this is not your first domestic violence conviction. It states here that the officer had concerns about your ability to follow all of the conditions of probation, and that's based on your prior criminal history. It says the officer could see a very clear pattern of deviant and assaultive behavior for both the defendant's outstanding bench warrants are for assaultive crimes, and one of which was only just committed in June 2023. Interestingly enough, that would have been right around the time you were arraigned on this matter. The officer states here that they find you to be a risk to the community and to the victim that was involved. Officer also indicated that you took no accountability for this offense or the use of force that was inflicted. Officers recommended denying 769.4A because your prior criminal history would make you ineligible, and the officer finds that a jail sentence with credit for time served would be appropriate in this matter. I reviewed your prior criminal history. You've got a host of things pending, and your entire criminal history reflects assaultive behavior. I have no reason to disagree with the recommendation of the probation department, and I'm going to adopt that recommendation. You will be sentenced to 180 days Ingham County Jail, credit for 22 days. You need to turn yourself in within 24 hours.
Your Honor, I know Ms. Korndike had spoke with our client directly, and I assume his position still remains the same, that he would like to withdraw his plea then if the plea agreement was not honored.
Okay, so he wants to withdraw his plea and continue to his exam?
Correct.
Okay, and so because there was a Killebrew agreement of no upfront jail, I will grant him the opportunity to withdraw his plea and we can continue to exam. I'll give you an exam date.
Thank you, Your Honor.
November 9th at 9 o'clock in the morning.
Okay.
Do you have any questions for the court today, Mr. Williams?
No, ma'am.
Any additional matters for the record today, counsel?
No other matters, Your Honor.
You're all set. Thank you.
Thank you.
On the record in the matter of the people of the state of Michigan versus Demond Bisbee, file number 23-00863. Counsel appearance.
Morning, Your Honor. Attorney Derek Edge, Cost Public Defender on behalf of Mr. Bisbee, who is in the courtroom standing to my right.
Oh, I think she took the correct motion. Thank you. Okay, today was the date and the time set for sentencing. I don't have a pre-sentence report. You know why?
Your
Why?
Honor, Mr. Bisbee was in and out of the hospital. He was in a mental health facility several times, my understanding. And then after that, he was in Detroit and got stabbed in the Detroit area, Lansing area, he got stabbed. And he did contact probation to try to get PSI done around, I think it was around October 10th. And they advised him that didn't have enough time to meet with him or do it prior to sentencing, my understanding.
Well, yeah, because you can't go on the 10th to go and get a report when I told you to get it done on the 25th.
Yes, I was in the incident with my neck got cut.
When?
As soon as I got out of St. Lawrence.
When were you in St. Lawrence?
August, or like the last week of August, last 2 weeks of August, maybe.
What
As soon
date,
as I got out.
give me the date.
I wanna say-
You were here the 25th.
I wasn't in here
You were here, you pled guilty on the 25th.
of August.
Absolutely.
Okay, so like it was back to back. As soon as I got out, all that stuff happened. And I called to try to make sure I can time and stuff, but my neck, the hospital. It was like,
Your Honor,
I
my
apologize.
notes I received, it was around August 30th, and again, around 1st of September, 5th of September, his aunt called and advised that he was still in the hospital. And then around the 12th is when he got stabbed, is my understanding, September 12th.
September 12th. So he was, I refresh my recollection, was he in custody when he took his plea?
Yes, Your Honor, I'm pretty sure he was in custody at the time of the plea.
And when did he get out of custody?
That day.
You got out that day, and I told you you were supposed to report to probation within 48 hours of release from custody, correct? And so 5 days went by, you did not report, correct?
Yeah, I ended up being inside the psych mental.
That was 5 days later.
Yeah, more less than 5 days later.
Well, your attorney just said it was 5 days later.
It was less. I think I was out like 2 days.
And then you got stabbed in September.
Yes.
And when did you get out the hospital for that?
Maybe like 3 or 4 days later, and ended up going to Detroit. I was just in a panic, and then I got hurt. People after me, I got shot. Just a lot of stuff.
Okay,
I apologize.
so what are you gonna do?
As far as going to take the assessment.
Yeah, how am I supposed to sentence you? You've not done anything to prepare yourself to be sentenced. And as of right now, I don't know that I'm confident that you would be successful on probation. So what am I supposed to do?
I could do the probation and do the assessment on the day you do.
Oh, you want me to put you on probation and take your word that you're gonna do what I told you to do when you didn't do it the last time?
Yes, ma'am, I won't have no problem doing it. I won't have the hospital or CMH, anything that helping me.
Your Honor, he does have some health issues, so.
I recognize that.
I got my phone and everything. I'm right here. I stay at the mission right now, so it wouldn't be no problem for me to go in the morning or any time to go see probation.
You're gonna go see probation right now.
Okay.
You're resetting your sentencing. Does he have a matter also pending for Judge Ward?
That case was dismissed, Your Honor.
Okay. December 7th at 8:30.
November 7th, Your Honor?
December.
December 7th. Thank you.
Am I supposed to go on the probation?
I'll
You
just-
said today.
I'll escort you down right after.
Immediately.
Okay.
Don't pass go. You're going right to the 5th floor. Any additional matters for the record?
Thank you.
You're all set.
Thank you.
Let's see here, 7 minutes. Yeah, which matter are you here for? Okay, I see Ms. Lenitra Middlebrook. Did you meet with her already? We did. Okay. On the record in the matter of the LAFQ versus Lenitra Middlebrook and Addiction Salon, file number is 15-01722 GC. Council appearance.
Yes, good morning, Aaron Rombach here for LAFQ.
Okay, today was the date and time set for in-person proceeding. I believe, and Ms. Middlebrook is present in person. I believe the issue was some outstanding documents. Did you receive what you were subpoenaing?
I did not receive one piece of paper today.
Okay, what is the documents that's being?
Well, we're looking for she keeps claiming she's been unemployed for a year, but her bank statements that she did provide show substantial deposits. In July, it was 3,000. In June, it was almost 15,000. In May, we've got over 20,000. April, close to 6,000. March, almost 7. February, over 14. And then, so they're all coming from Cash App, Zelle, Apple Pay. We don't know where she's working. We don't know where the money's coming from. And she says she's unemployed, and I don't believe a word she says. We've been here like 5 times.
Okay, so you're requesting what pieces of information?
Same ones that were requested last time, which I wasn't here for. I would like to see the Cash App, the Zelle, the Apple Cash. There's a few LLCs she's involved in. I don't know if there's any accounting for those. I request you find her in contempt. It's just too many visits to the courthouse for this.
And what legal authority are you withholding this from?
So I was explaining to him, even when we pull up my bank statements, I told him, unless you're sitting with me, it would be too confusing to understand. So I have 8 children. So I have been unemployed. I told him I come into Michigan and I work, like I told him I'm working right now. I work like 4 days out of the month, but I'm using my mother's address. I had a situation that happened to me, which is none of his business, but where I was displaced. So at that point in time, like, you can, okay, somebody sent you this amount of money. Okay, they did, but you don't know what they sent it to me for. So my issue is, even if I gave you my Cash App, if you're basically saying, well, this is the amount of money you received, you don't know if it was allocated to go someplace. So if I'm agreeing to go into a payment arrangement with you because of a misunderstanding that happened last year, y'all didn't come and pick me up. I turned myself in because I'm willing to take care of the matter, to make a payment arrangement and move forward. If you're not willing to do that with me, I don't know how much, I don't know what more I can do for you. So if I gave you my Cash App, you're not gonna understand it. You're gonna think, okay,
I can always put you under oath and question you about it.
Yeah, and I
you have to turn it over.
Okay.
Court order. You have to turn it over.
Okay.
Otherwise, you can be filed in contempt of court. Let them figure it out. If they have any questions, they can ask you. Just because they see something in Cash App doesn't mean it's something that they can garnish. So, but they have a right to review your finances to see how they can get their judgment.
But what if that's not a part of my finances? So have you ever been in a situation where somebody said, can I Cash App you? Because they don't have cash on them, or whatever the case may be. So if you sat and go through my, and that's fine, I'll garnish. I mean, I'll send it over to them, but it's not gonna be accurate. So I'm trying to save them the hassle. I gave them my Navy Federal, then they went to Navy Federal and already tried to garnish.
Right, but you filed, I'm assuming you filed your taxes, correct?
Yeah, and they take my state every year. So
okay, so I'm sure they're gonna cross-reference whatever they get with your tax returns, and then there's that. And any questions that they have, they can put you under oath and get answers based on that. But it's better in your interest to be forthcoming versus to try to hide the ball, because that represents, it makes them feel like you're trying to hide something. And especially if they're seeing large amounts of money come through a Cash App and a Zelle. We're talking about tens of thousands of dollars.
No, yes, all those tens of thousands didn't come through Cash App.
Well, what this is the allegations being made is that there's large sums of money coming through Apple Pay, Cash App, Zelle, other means, and better let them go through it so that, I mean, you don't want the federal government to pick up on that because they're gonna have more questions than why someone texts or Cash Apping you $14,000 for them because they don't have cash on them.
That wasn't the issue.
Well, nonetheless, you have to turn over this document as part of this proceeding, or these documents as part of this proceeding, so they can review them. They can review them with you. They can review them on their own. They can ask you questions following that because they're just trying to figure out how they can recover on the judgment. The alternative is to pay the judgment, then we don't have to turn over your personal information anymore.
And I said, I'm willing to do that.
She told me I'm not bringing it.
Not bringing
the
Cash App. Say I won't bring it.
She said,
no, I said she can pay the judgment.
I said, I'm willing to
she pays the amount, then she doesn't, there's nothing else to do.
Yeah, I understand.
Absolutely.
He's 8 years old.
They don't have the right, they don't have to take a payment plan from you though. That's something that they don't have to do at this point.
And that's fine. So
but you can turn over the full amount and then this ends.
Absolutely. So, and if I had the full amount to give them,
right,
I would just get. You think I want to come in here every month?
I don't think
the time y'all don't.
They don't either. It's this is from 2015. This case, the debt I'm sure is older than that. And so they just want to get it resolved. And so I think you want to do the same thing, because I'm sure you don't want this on your credit. So.
And I contacted him. He said it's in 2015. I said, absolutely. So the fact that I'm even willing to just come so we can get to some sort of agreement, even if it's not an agreement, like you said, whatever. I told him I'm willing to do what I can. I even told him let's make a payment arrangement. When I have extras available, I don't mind dumping it on there. So in 2015, my financial place that I was in was way different than now. 2015, I couldn't pay it. That's why I'm here. So now if I'm saying, okay, I can pay it, but let's make a payment arrangement, they either can or won't, and
Well,
whatever.
they want to see how they can properly.
So if I gave them everything except my cash out statement. So if you're saying, you know what, I see that this amount, this month you have 14,000, this amount you have, go off of that. You need the cash out too. Y'all got everything.
Well, they want to see what it was coming in for. Maybe it'll show that it's not money that belongs to you. They don't know. They have to see that. It could be beneficial to you.
It could. That's why I thought I wish they would have had kept the payment arrangement then, because my financial situation I'm in now is much worse. So if we're going based off of that, it's gonna be slim pickings.
There was a payment arrangement, but there's been no payments.
And you know, and I explained that.
Okay, so she said she's gonna turn over the information. When are you gonna turn it over, ma'am?
I don't even know how to print cash out statements. I don't even know if you got cash out statements, but if you do,
I think they probably email them to you.
Okay, so yeah, I'll figure out how to get a hold of one and I'll get this.
So if they should be emailing them to you. I don't know if they're in your actual Cash App application. There may be a way to get them in there. How many months worth of Cash App are you looking for?
I would like to see the last 6 months of all the accounts, Cash App, Zelle, Apple Cash.
And she can email those to you?
And the most recent ones from the Navy Federal. Yes, you can email them or mail them.
Okay, because she may
probably screenshot them on her phone.
That's fine. Whatever you want.
Okay. How can you do that within the next 7 days?
If you want to take screenshots, we can go sit outside. I can
Wonderful.
screenshots.
Let's do it. No, let's do it. No, we're gonna do it today. Thank you. Off the record.
Can't do that. You won't get it.
Oh, no, she's here. She came in just for this.
It's gonna be more than just.
On the record, in the matter of the people of the state of Michigan versus Brandon Williams, file number 23-02812, council appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Lyle Bear appearing on behalf of Brandon Williams, who is standing to my right.
Okay. Today is the date and the time set for preliminary examination. Is there a motion to dismiss on this?
Your Honor, the people have subpoenaed witnesses. I have not been made aware of the subpoenaed witnesses' appearance here today. So at this time, the people would be unable to proceed.
Counsel. Motion to dismiss is granted without prejudice. That means that the people have the right to reissue the charge against you. Okay, sir? Okay, and so hang tight, we'll get you a copy. We'll get you a copy of your filing in just a moment, okay? Give it. Let me see. Okay. Thank you.
Thank you, Your Honor.
You're welcome. Stephen Williams here? Oh, we took care of him. Maurice Myers here?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Maurice Antoine Myers, file number 23-0984, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Maurice Myers, who is present standing to my right.
Okay. Today was the date and the time set for a preliminary examination. Are we continuing to or proceeding with the exam today?
At this time, Your Honor, the people have subpoenaed witnesses. They have appeared. People are ready to proceed. However, after conversations with defense counsel, I believe the defendant will be waiving 21 days. I would leave it to defense counsel for more, Your Honor.
Thank you, Your Honor. Thank you, Mr. Brodowitz. Yes, we do have an offer of 2 counts of assault and battery. At this time, we would like to waive the 21 days and have it set for a plea. In that time, I would like to review with Mr. Myers the offer, just to make sure that it won't have any complications for his Section 8 housing.
Okay, so Mr. Myers, you have the right to have a preliminary examination within 21 days of the date of your arraignment. Do you understand that? Okay, so it looks like you were arraigned on this back on September 29th. I see here where the offer was extended back on October 11th for you to plead guilty to a added count 2 of assault and battery and an added count 3 of assault and battery, and that the people would dismiss count 1. You want time to consider that offer? You don't understand what, do you understand what I said? Okay, the people offered you to plead guilty to an added count 2 of assault and battery and an added count 3 of assault and battery. And in exchange for that, they would dismiss the original count 1, which is an assault with a dangerous weapon. That's a felony. So count 1 is a felony. They're offering you 2 misdemeanors. Did you want time to consider that offer?
Time to consider this.
Okay, you want time to think about it and have your attorney look into that and how it affects you?
Yeah.
Okay, and so you're willing to waive the 21 days for her to do that? The timeline that I told you you had, which is within 21 days of your arraignment, you have the right to have a preliminary examination. You understand that?
Yeah.
You're willing to waive that 21-day timeline so that we can reset this?
Yes, I would like to come back.
I'm sorry?
Well, excuse me, I would like to come back like.
Okay. November 9th at 1:30. November 9th at 1:30 for a plea.
At 1:30.
Correct. Any additional matters for the record today?
Nothing from the people, Your Honor.
Nothing for defense.
Okay, we'll get your notice to appear in just a moment, Mr. Myers. On the record in the matter of the people of the state of Michigan versus Percy Harrison, file number 22-01722, FY, council appearance.
Jeff Rodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Jacob Sorensen, work assistant public defender here on behalf of Mr. Harrison. He's in custody. He should be downstairs.
It's present via Zoom.
It's present via Zoom. Okay.
Okay, today is the date and the time that was set for a plea, I believe. Is that correct?
That's correct, Your Honor.
Yes.
Okay, Mr. Brodowitz, what was the offer?
Yes, Your Honor, I believe at the time the offer was for Mr. Harrison to plead to this file with restitution. I believe he has another file open. District court. I believe the offer was restitution on both. Unfortunately, my internet is down and I can't pull it up right now. But I believe the offer was to plead to this count as charged, restitution on both files. At which time the people would then dismiss the other file in 50-50, Your Honor.
Mr. Searns?
That's correct, Your Honor. I'm going to request that the court allow Mr. Harrison to plead no contest to this. Mr. Harrison's been in custody now continuously since June 30th, 2022. I'm going to request a same-day sentencing. In terms of restitution, I would just request to keep the matter open and schedule a restitution hearing. I believe the estimates are going to be probably around $2,000 for the damage to the windows. The commission, I believe the deal request is still outstanding at this time. Thank you.
What's the purpose of the no contest plea?
I like a memory, Your Honor.
People object to that?
No, Your Honor.
Mr. Harrison, did you hear everything that was stated in here today? Mr. Harrison? Mr. Harrison? This is consistent with how it's been ever since the first time I've seen him, which was June 2022. We will not continue with the no contest plea. It's not responsive. I know he's already undergone a psychological evaluation. I don't know what's going on, but we're gonna have to get him in here so that you can talk to him in person. And for some reason, Jill was not brought over today, so I'll reset this and then you'll have an opportunity to talk to him and gauge his mental state.
Thank you, Your Honor. He was confident when I talked to him on Friday, but it could just be an audio issue. I'm not sure, but I'll follow up. Thank you.
Sounds good. You're all set, Mr. Harrison. We call the jail. So for the hour. Yeah, you said another play. I think, I don't know if they're gonna bring these other people over or not. I don't know what the plan is. They said that they were over there just for running late, so I don't know if they're here yet. Got it. On the record in the matter of the people of the state of Michigan versus Ali Gayet, file number 23-02911. Council appearance.
That's Ms. Smith's, Your Honor. I will go grab.
And Mr. Carter's on hold, which is the good thing. I don't know if you want to call him together.
I did, but we don't have a prosecutor, and then Mr. Carter just left with his client. Okay, Mr. Vincent?
Yes, Your Honor. Good morning.
Good morning. Is your client present?
Sitting right next to me, Your Honor. Say good morning to the judge. State your name.
Good morning, Your Honor. Timothy Allen King.
Okay. On the record, in the matter of the people of the state of Michigan versus Timothy Allen King, file number is 23-02216. Appearances for the record.
Good morning, LaDonna Logan on behalf of the people.
Good morning again, Your Honor. Michael Vincent on behalf of Timothy King.
Yep.
What happened?
They said that you weren't responding, Your Honor.
Okay, I apologize for that. Today was the date and the time that was set for a hearing. My understanding is that there was a motion for a forensic evaluation. I do, however, want to address with you, Mr. Vincent, the fact that your client was supposed to get his fingerprints taken care of and they've not been done.
Yes, we had got fingerprints done at the Washington County Sheriff's Department, and we've been informed that that is not good enough. They want them fingerprinted at the Lansing Police Department, if I'm correct.
That's correct.
He will comply with that order, Your Honor. He has a friend here that comes with him who's waiting out in my waiting room, and we'll make arrangements for him to get to the Lansing Police Department to be fingerprinted.
Okay, when is that going to take place?
As soon as possible, Your Honor, maybe today. Can you do that today, Mr. King?
Yes.
Yes.
Okay, sounds good. And I recognize that you are on the same room, but I need to see both of you for the proceedings. Thank you. Okay, and so today you wanted to make a request to have him undergo a forensic evaluation?
Yes, Your Honor.
I don't think they provided paperwork. Did you provide any proposed paperwork for forensic?
Yes, we. Pardon me.
It was emailed to Addie. Yes.
It was emailed to Addie.
And Nicholas.
Okay. Okay, so I do have a copy of your request to have him undergo an evaluation for competency and criminal responsibility.
Yes, Your Honor.
Okay, you're indicating that you're having some difficulty when it comes to meeting with him to help formulate his defense, that he's unable to stay focused.
Yes, Your Honor.
Okay, you believe that some of his communication and interactions with you border illogical or delusional thinking?
Yes, Your Honor.
Is there a prior history of of mental health?
I am not sure about that, but I am sure I've been doing this for a long time by looking at me. And I also had him talk to Dr. Schreiber, and he and I both agree that he suffers from illogical thinking, sometimes delusional. He's in a divorce situation, which I think also contributes to the difficulties he's having. Mr. King is a very nice man. I don't want to create the wrong impression for Your Honor. He's a very nice man, but it's been almost impossible to get him to focus on the charges he's facing, the very serious charges he's facing. And again, he's an exceptionally nice man.
Thank you. And Ms. Logan, is there any objection from the Office of the Attorney General?
No, Your Honor.
Okay. Based on the indications provided to the court on this record and in your motion, I'm going to grant your request. He'll be ordered to undergo evaluation relative to criminal responsibility and a forensic evaluation, we will adjourn out his need for a preliminary examination pending a report from the Department of the Center for Forensic Psychiatry. Just in case you were not aware, but you may be, they're inundated recently. And so as it relates to criminal responsibility, that's been taking over 6 months to get those evaluations.
I've heard that.
Okay, so, but we will adjourn this out to get that taken care of.
Would it be better to set this than a prelim exam?
Can you restate what you said, because it broke up a little bit?
Yes. Would it be better to set this for a PCC pending the results rather than a preliminary exam?
What we'll do is we'll set it, at this point, we're not going to set any date. We're going to set a review date on the competency. And so once we get a determination as to whether or not he's competent or not, then we know how to move forward.
Thank you.
Okay, and we will set an internal review date because we typically have to follow up to see if we get a report, because it's, again, been taking quite some time for us to get reports.
That's been my experience also, Your Honor.
Okay. And then he'll get the fingerprinting taken care of at the Lansing Police Department today or no later than tomorrow.
Yeah, we're going to try to get it done today. His friend is here. Okay. And the traffic should be cleared by now to get up there fairly quick. We just got to locate the exact location of the Lansing. It's the Lansing Police Department you want him to go to, correct?
That's correct.
Good. I thank the court for its courtesy in allowing this to be done by Zoom. I do appreciate that.
No problem. Any additional matters for the record, counsel?
I'd just like to thank the Attorney General, Ms. Lalonde, for her cooperation in this matter. Thank you so much.
You're welcome.
We're both from the east side, right?
Have a good day, both of you.
Thank you.
Take care. Thank you.
You're welcome. Actually, was there supposed to be another one? Yeah, she just put the other one on there. Okay, sounds good.
We're ready on Easley and Martins, Your Honor. We don't expect either of those to.
Okay, what happened with you went to go get the other assistant?
Yeah, she said, and this is her words, not mine. She said they were not ready yet.
Okay, that's for Bolden and Guyette?
Yeah, Bolden and Guyette.
Yes.
Okay. Not yet. And as I was walking down, I ran into Mr. Carter as well. He was still speaking.
Yeah, I saw him step out with her, so I wasn't sure what's going on. Okay, and you're ready on whom?
Easley and Martins. You know.
Mr. Milk says he's not ready.
Oh, no, Mr. Milks is totally ready.
Are you sure?
I don't know, not anymore.
Okay.
Yeah. Go Pats.
I thought Easley was in custody.
He is, but I don't think we'll need him for.
Yeah, I don't.
Okay, on the record in the matter of the people of the state of Michigan versus Louis Emmanuel Easley, file number 22-03541, counsel appearance.
Yeah, Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Easley. Mr. Easley is not present, but I do not believe that his presence is going to be necessary today.
Why is that?
At this, at this time, Your Honor, the people have subpoenaed witnesses. I've called the hallway in the courtroom. I have those witnesses, I believe, have not appeared at this time. I did have contact with one of the complaining witnesses last time. She told me they would be here today. However, as I stated, I have not seen them here in the courtroom, in the courthouse today. So at this time, the people would be unable to proceed. Sorry. My apology. They are here, Your Honor. So we are ready to proceed with that.
We will likely need Mr.
You think we might need him now?
We might need him.
Didn't I say you weren't ready?
You did. I'm ready on the other one. Right?
Yes, we're ready.
Should have put money on it. Okay, sounds good. We just need to know if the jail brought, they're here. And we're writing that? Are we running, or do you know if we're gonna run that, Mr. Brodowitz?
No, we're not going to run that.
Okay, so we can bring him up.
There will be a competency request.
Okay, we'll have him brought up. Thank you. And the other one you have was who?
Mr. Mark.
On the record, in the matter of the people of the state of Michigan versus Jeremiah Marcos, file number is 23-02623. Council opinion.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Mills, on behalf of Marcos, is present and exchange my right at this time.
Today was date and the time that was set for preliminary examination, and we had reset this previously so he could be assessed for mental health support. Has he had an opportunity to get that done?
Your Honor, yes, we have had him. He is legally eligible. However, today is the date and time for the preliminary examination. I do not believe people are ready to proceed. We did request that subpoenas be sent out for purposes today. I don't know the words, Mr.
No. Yes, Your Honor. I did have contact with the complainant, with the victim, the complaining witness in this matter last night. In checking our system, Your Honor, I'm not sure what happened, but I don't believe a subpoena was ever sent out to him for today's date. When I talked with him last night, he confirmed he had not received a subpoena for today's date. I have had a very good contact with him. He also did appear for the date of the first preliminary exam. So at this point, Your Honor, as mental health court was the offer and we have had good contact with the victim, I would ask for an adjournment in order to get the victim here in order to proceed.
If he's already had contact with the victim, I assume Mr. Brodowitz has told the victim he needed to be here today for the purposes of at least today's preliminary examination. He's still not here. I don't think it's a notice issue.
Well, I don't even know why we would have a witness subpoenaed if on my note says that he was being assessed for mental health court. Why are we subpoenaing witnesses for that? Is he going to mental health court or no?
Your Honor, we wanted to see whether or not he would be, the complaining witness would actually be appearing today.
Okay, but the complaining witness appeared before.
Correct. That's why we also wanted him here today, Your Honor.
Okay, well, I'm going to give him adjournment. So are we running an exam? Because we don't need to tie up exam dockets for no reason.
Not today, Your Honor, no.
No, are we gonna run it on the 16th? Because we almost had to put something out into December today. Because our slots are filled up, and I don't want slots filled up for us to say, oh, well, we're going to mental health court.
I understand what you're saying. Yes, Your Honor, we do anticipate, I'm sorry, we do not anticipate running the preliminary examination. We will be continuing forward looking to the mental health court. We have legally, he is eligible. We have to make sure that he is clinically eligible.
You said that for PCC, please.
Okay. So we can do it at 9:30.
Okay. So we can do it at 9:30 then instead of 2:30.
Thank you, Your Honor.
And what date was that again?
November 16th. Additional matters for the record today.
Nothing from the people, Your Honor.
And nothing from the defense. Thank you, Your Honor.
Okay, we'll get you notice to appear in just a moment. Ms. Logan, I don't know if the other matter is going to appear today.
Your Honor, I believe it's scheduled for 11. I just figured it'd be easier for me to stay on, if that's okay.
It's scheduled for 10 on my docket.
Oh. I'll reach out to counsel.
Thank you.
I'm still here.
Thank you.
It's my report. Okay, back on the record in the matter of the people of the state of Michigan versus Edward Faust. I think I have a correct report now. Let's see. I do. Okay. Do you have a correct report now as well?
Yes, sir.
Okay, do we need to make corrections, updates, or deletions?
No, thank you.
Okay, you can make allocution.
Thank you, Your Honor. As I mentioned before, and as the report indicates, he's taken responsibility for his actions. He recognizes his drinking problem. The recommendation is for batterer's intervention, and he's confident he can complete that successfully. It is the clerk to adopt a recommendation of probation. Thank you.
Thank you. And Mr. Frost, thank you for your patience today while we got this matter cleared up. I reviewed the pre-sentence report and the recommendation.
There was the victim here who wanted to make a statement as to the no contact. If there was, I'm not sure if there was one. I've not seen the pre-sentence report at all.
Well, it doesn't matter what the pre-sentence report. It doesn't matter what I said. So if she wants to talk, she can talk.
Yeah, for the last time I was here.
Hi, can you state your name for the record, please, ma'am?
Laura Marie Faust.
Okay, and what's your relation?
Oh, we're married.
Okay, and you wanted to share something?
I just wanted to say that I was okay with him coming over.
Okay, you don't believe that there's any further threat to your safety?
No.
Oh, thank you. Anything else you wanted to say? The report doesn't request it.
Okay, I wasn't sure, Your Honor, and that's why I didn't know if it was necessary or not, but.
Nope, it's always good to hear from the victim, and that's her husband. She doesn't want to continue the no contact order. I think the recommendation is appropriate, and that is for a term of probation and to grant 769.4A status. It also is a recommendation for you to attend batterer's intervention program, which it sounds like you're already willing to do. So I'm going to adopt the recommendation. It's 12 months probation. While on probation, you're not to engage in any assaultive or threatening behavior, okay? I will grant 769.4A status, which will make this non-public upon completion or successful completion of your probation, okay? You're not to have any firearms, ammunition, or weapons of any kind while on probation. You're not to use, purchase, or possess alcohol, marijuana, or controlled substance without a valid prescription. Do you understand that?
Yes.
I'm going to order that you maintain employment and provide evidence of that to probation. You will be required to submit to random preliminary breath testing and or your analysis testing. You're responsible for the cost of that, okay? And then you will be ordered to complete batterer's intervention program, okay? Do you have any questions so far? While on probation is a $30 per month oversight fee that you are responsible for. 12 months at $30 would amount to $360. There's a $75 crime victim rights fee that you must pay, plus a $50 state minimum cost. I'll waive discretionary fines and costs at this time. That brings you to $485 for fines and costs, and you'll make monthly payments on that, okay?
Yes.
Lastly, there's an advice of rights as to probation, and it states that you have been placed on a term of probation before the 54A district court. Your program conditions are specific to address your assessed risks and needs, except for domestic violence, criminal sex crime, stalking, or an offense where the defense of guilty but mentally ill was asserted. You may be eligible for early discharge from probation, okay? You are on a term of probation for domestic violence, so that means you would not be eligible for early discharge. You understand that?
Yes.
Do you have any questions about those rights? No. So you're going to check in with probation before you leave here today, so that they can make sure they have accurate information in order to go over the judgment of sentence. Any additional matters for the record, counsel?
Nothing from the people here.
Your Honor, just to be clear, it's okay if he goes home?
Correct. I'm not continuing the no contact.
Thank you.
You're welcome. And for the record, it says my note from August 25th was that I amended Oh, I didn't. Okay. He made a motion to amend bond back then. To go home. Okay, I think I denied it at that time. Well, you can go home now. Thank you. Zachary Cowden. Yep, you just stop at the 5th floor and check in with probation, okay? On the record in the matter of the people of the state of Michigan versus Louis Easley in file number 22-035541, counsel appearance.
Jeff Brodowitz on behalf of the people, Your Honor.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Easley. Mr. Easley is present and seated to my right at this time.
Okay. How are you, Mr. Easley? Well, great. Today's the date and the time that's set for a preliminary examination. Counsel, how do you want to proceed?
I will defer to Mr. Milks here.
Your Honor, I'm truly torn at this point. I've got some concerns regarding my client's competency. I had an opportunity to speak with his mother. Does not believe that there's a competency issue. I do have paperwork filled out regarding an order for competency examination. There's just several issues that, and it's some of those issues that I'm rattling around right now that are just a little more on the confusing side. I haven't spoken to the complaining witness in this matter too. I realize that there are some significant hurdles for people to get over at this time, which would make a preliminary exam prudent. However, as the court already knows, we obviously cannot proceed forward if there is some concerns regarding the client's competency.
You maybe need some more time to talk to your client.
I have a moment.
Someone behind you nodding.
I may have a few moments, Your Honor.
Take your all the time you need. We've already gone beyond the 21-day timeline. So.
Over here. Here.
Yeah, maybe Ms. Donnelly will let you guys in there.
Behind the curve.
And then everyone else is probably already in custody or in custody as well. Are we running yours, Ms. Donnelly?
No, it should be a plea, Your Honor.
They failed to transport Deanna's lead. So
They did?
We won't be handling her minute.
He what?
She's not transported.
Nobody said they didn't have anybody go get her, and the county didn't have anybody bring her
That's not good.
She does have a case in Judge Ward's court tomorrow.
I won't be here. We already weighed the timeline, so
Yeah.
there's that. Deanna's plea. That's on both matters. Were you expecting to run an exam?
No, we were expecting to plead to a misdemeanor.
Yes, Your Honor. If I can just put, I don't know if we want to go on the record briefly, just so I can put the offer on the record, Your Honor.
Waiving your client's appearance for that?
Yes.
On the record in the matter of the people of the state of Michigan versus Deanna's Lee, I have file numbers 19-04330 and 04332. Councilor King.
Jeff Broadway on behalf of the people, Your Honor.
Good morning, Your Honor. John Abbott representing Ms. Lee. She's not present because she was not transported by the sheriff.
Okay. And you wanted to state an offer on the record?
Yes, Your Honor, as this case is from 2019, I'm not sure if there was an offer in the file or not. But looking back at the notes in the prosecutor's system yesterday, as I was reviewing this case, I believe the offer that was originally extended, and the offer we would be extending at this time, would be for Ms. Lee to plead to an added count 2 of joyriding with the 90-day misdemeanor option, Your Honor, for first offense, and that would be on file 19-04332 FT with an agreement to restitution. And with that plea, Your Honor, the people would dismiss file 19-04330 FY, as well as count 1 in the previous file.
Do you know what the restitution amount is?
Not offhand, Your Honor. The complaining victim did appear here today. He does have documentation that he will be getting to the prosecutor's office, so we should have a restitution number. Sure.
Okay. Do you want this up for a plea or another exam?
Your Honor, I think it's a fair resolution to the situation. I'm pretty confident Ms. Lee will accept it. Since she's not here, I can't actually ask her.
We'll set it for a plea. If she wants her exam, we'll reset it for an exam.
Thank you.
November 16th at 10:30. November 16th at 10:30. Any additional matters on today's record?
Nothing from the people, Your Honor.
There may be someone else covering it here.
Sounds good. Thank you.
10:30.
Correct.
11:16.
Back on the record in the matter of the people of the state of Michigan versus Mr. Easley. In council, you were trying to make it a determination as to whether or not you wanted to continue with the petition for a psych eval versus continuing to exam. How do you want to proceed at this time?
Thank you, Your Honor. At this time, Your Honor, we would like to run the preliminary examination. Having spoken with my client, that he'd like to do, I imagine this will go very quickly.
Sounds good. Are we ready to call your witnesses?
Yes, Your Honor. Can I just have 1 minute, Your Honor? I didn't get a chance to speak with him. Might just have 1 minute. It shouldn't take.
Sure. Okay, I see Clint Westbrook.
Yes, good morning, Your Honor.
Good morning. Okay, we're on the record in the matter of the people of the state of Michigan versus James Renner. File number is 23-02219. FY council appearance.
Good morning, LaDonna Logan on behalf of the people.
Good morning, Clint Westbrook on behalf of Mr. Renner.
Okay, today was the date set for a hearing. I think that the Attorney General was making a motion at today's hearing. Is that correct?
That is correct, Your Honor. Based on an agreement between the parties, the people are actually moving to dismiss the case against Mr. Renner.
Okay, and is that a dismissal with or without prejudice?
It will be without prejudice, Your Honor.
Okay, and is your office going to prepare a nollie for us, or did you do that already?
I have prepared one. I will get that to the court forthwith.
Okay, very good. And so, Mr. Westbrook, there's no objection, I'm assuming, on your client's behalf. Is that correct?
No objection, Your Honor. We do have that agreement for special consideration with the Attorney General's office, and we're excited for this result.
Okay, very good. So the motion to dismiss without prejudice will be granted, and we'll look forward to get that email from you. And you can send that to Judge Simmons Courtroom at lansingmi.gov.
Will do, Your Honor. Thank you.
Thank you. You're off the record.
Thank you, Your Honor.
You're welcome. Okay, back on the record in the matter of the people of the state of Michigan versus Lewis Easley. How are we proceeding, counsel?
Yes, Your Honor, at this time, I guess people just make note that I believe it was said that there were some questions about his competency, so the people would ask that Mr. Easley be referred. However, if the court is not going to refer him for competency, the people would, based on conversations with complaining victims, move to add a count 2 of misdemeanor assault and battery to the complaint, Your Honor. Amend the complaint to add count 2 misdemeanor assault or assault and battery, dismiss count 1, and ask that this matter be set for pre-trial, Your Honor.
Well, I don't have enough before me to make a determination that he needs to go have a evaluation. When he came in today, he was cooperative. I don't think he gave Mr. Bigelow any hard time coming up. I asked him how he was doing. He said he was doing well. He was very cooperative with his client. I mean, with his attorney, his attorney spoke to him over in the corner there. I don't have any information that would support the need to order him to undergo a psychological evaluation other than what his attorney would say. His attorney's been the one that communicated with him and doesn't feel that that's necessary at this time. Is that correct?
That is correct, Your Honor.
And so are you indicating that you're not prepared to proceed to exam today?
At this time, Your Honor, based on conversations with complaining victims in this matter, the people believe they would not be able to sustain the burden of proof on count 1 for felonious assault. So we would ask that, and again, the complaint be amended to add a count 2 assault or assault and battery, and this matter be set for a pre-trial, Your Honor. So with that, dismiss count 1.
So the motion to add count 2 of assault and battery against whom?
It would be against William Easley and or Moneta LeSure, Your Honor, the same victims listed in count 1.
Thank you, Your Honor. Your Honor, we would stipulate only for the reason that I believe if we were to run a preliminary examination, it would be the exact same outcome in this matter. So for those purposes, we would stipulate to the fact that the charges are going to change. I would just briefly note, Your Honor, that even though I did say that I had some concerns regarding competency, it by no means, I believe at this point, rises to the point where it's need for a competency examination. He seems to have a limited understanding at this time. Obviously, it's something we will continue to monitor and look over throughout this entire process.
Oh, sounds good. And again, I don't have any indication presently that would warrant me ordering him to undergo the evaluation. I do remember back in March, there was some concerns, but my understanding is that was addressed. And if a need was for him to undergo a evaluation, it probably would have been closer in time to then. I'm not sure, but I'll leave that to your determination since you're the one communicating with him at length. And so as it relates to the motion, that will be granted by stipulation. So count 1 is dismissed and count 2 of assault and battery will continue to a pre-trial. November 6th at 10:30. At 10:30, yeah. November 6th at 10:30. Is there an offer?
Not at this time, Your Honor. The people will extend an offer soon.
I'm sorry.
November 6th at 10:30.
Thank you, Your Honor.
Any additional matters for today's record?
Nothing from the people, Your Honor.
Nothing from the defense. Thank you.
You're all set. Mr. Bach and Ms. Middlebrook. I don't see her. Okay, back on the record in the matter of Lapke versus Middlebrook, were the parties able to confer and exchange information?
Yes, Your Honor, we got a bunch of emails with statements. It's all a little bit cryptic, but it doesn't matter because we've agreed to an installment order At 150 months, starting November 15th, we both signed it, and plaintiff has no need to try to reschedule this again at this time.
Wonderful. I see the order.
That approach?
Yes, please. Thank you. Okay, so I have here an installment payment order that you're agreeing to. Is that correct?
Correct.
Okay. I'm a little confused. Okay. Past total amount due $5,699.35.
That's the judgment amount from that date. You know, I do have closer figure, but I think that it calls for the judgment amount, not the balance.
Amount of judgment including costs.
Yeah, that was the judgment amount back in 2015. You have a printout with a more recent amount. Balance is approximately $7,368.28.
Okay. And you're gonna pay $150 monthly beginning November 15th, correct?
That's correct.
Okay, and she's gonna make that payment directly to
Smith and Johnson in
Smith and
Traverse City.
Johnson. Okay, very good. And you had that information to make the payment that way?
Yeah.
Okay, and then so long as you're making those payments, no writ of garnishment on this judgment will issue for your wages or labor until further order of the court, okay? Do you have any questions at this time?
No.
Okay, we'll get you a copy of this order in just a moment.
Thank you very much, Your
You're
Honor.
welcome.
Try to take so much time.
No problem. Glad you guys came to a resolution. Do we need more time on? I have one for this guy. Do we give another one?
We have Golden and Guyette. Yes, not sure. I apologize.
Okay.
But yes, both are ready to go, Your Honor. Both
Okay.
attorneys and both defendants are here.
Okay, I only have paperwork on Diet. Do we have paperwork for the other?
Yes, I'm sorry. Next,
Oh, okay.
may I approach?
Yes. Thank you. Okay, on the record, in the matter of the people of the state of Michigan versus Ali Guyette, file number 23-02911 FY, Council of Ten.
Good morning, Your Honor. Assistant Prosecuting Attorney Melanie Smith on behalf of the people. Aaron Robinson, Assistant Public Defender.
Okay, so yeah, today was the date and time set for preliminary examination. I do have here a plea sheet. It indicates that the people are offering for you to plead guilty to child abuse fourth degree, I'm sorry, no contest, child abuse fourth degree, and that there's a killable to no upfront jail and with 24 months of probation. Is that accurate?
That is accurate, Your Honor. The basis for the no contest plea would be potential civil liability. And we've provided the court with Lansing Police Department Report 22-519-11658 to the court. I did review the highlighted portions that I thought were pertinent with Ms. Robinson, and I believe she was in agreement with that.
Okay, Ms. Robinson?
That's correct, Your Honor.
Okay, and so Mr. Diet, you want to accept that offer and enter a no contest plea at this time? Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, I have an advice of rights and plea information sheet here today. There's a signature at the bottom. Whose signature is this? Did you read this document? What, you sure it's yours?
Yeah, because, yeah, of course. Mine, yeah.
Okay, do you remember signing this?
Yes. Yeah,
Okay, okay, very
I
good.
have really bad.
Okay, you look like you've never seen it before.
No, I was making sure.
I was getting nervous. Okay,
No, ma'am.
okay, and so have you read this document?
Yes, ma'am.
Do you understand the rights listed here?
Yes, ma'am.
Do you have any questions about these rights?
No, ma'am.
You want to give up all of these rights today in order to enter a no contest plea?
Yes, ma'am.
You understand that you have the right to proceed to a trial in this matter?
Yes, ma'am.
You have the right to jury trial. At the time of jury trial, you have the right to require the prosecution to prove your guilt by proving each element of the charge being brought against you beyond a reasonable doubt. You understand that? You have the right to confront in court and cross-examine any other witnesses that the prosecution intends to call. You have the right to call your own witnesses or present evidence at trial that you believe further defense of the charge being brought against you. You have the right to remain silent at trial and not have silence be used against you. You understand each of those rights? You're willing to give up all of those? Anybody threatening you to get you to waive your rights and enter a no contest plea? Has there been any promises made to induce you to waive your rights and enter a no contest plea?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
Do you understand that a no contest plea could result in a conviction that you may need to report to your employer or to a future employer?
That's not.
Okay. And you understand that a no contest plea could result in a conviction that may have impact on travel or immigration status that you may be seeking. Like you may want to go on vacation to Toronto and you may not be able to. Okay. And you understand that you still want to give up your rights? Okay, I have a police report here from Lansing Police Department. This is report number 225191168. States here that on or about December 9th, 2022. The area of 5705 South Martin Luther King, City of Lansing, Ingham County, State of Michigan. Officer Jacqueline Lindeman received a report of child abuse taking place and made contact with the alleged victim, who was a 7-year-old at that victim's school. Okay, the principal advised that they were starting out by asking the alleged victim why he was sad earlier that morning. The victim replied because of this and pulled his arm out of his left shirt sleeve. There were 3 red contusions on his forearm. All of them appeared to have been made by some sort of object. They were all the same size and shape with a faint dark blue bruising around the edges. The alleged victim was hesitant to elaborate and stated that he did not want CPS called. He stated his mother has told him that if CPS is ever called again, she will beat his ass. The principal asked the victim who caused the marks to his arm, and he stated Allie. The officer confirmed with the victim that Allie is the mother's boyfriend. However, the victim considers him a stepfather because his own father is in prison. The victim refers to Allie as dad or daddy. Any further factual basis?
People are satisfied. We're satisfied as well.
I find the reason for a no contest plea to be appropriate. I am satisfied with the factual basis, and I will find or make a finding of guilty by way of no contest plea. Find your plea to be made freely, voluntarily, and intelligently. There is a Killebrew agreement in here, and that is for no upfront jail and 24 months of probation. I'm not a party to that. So you're going to be referred to our probation department so that they can prepare a pre-sentence report with a recommendation as to how you are to be sentenced. And then I'll also get an opportunity to review your prior criminal history. If I make a determination at the time of your sentencing that I am going to deviate from your Killebrew agreement, I will let you then withdraw your plea, okay? Your sentence is going to be December 7th, 2023 at 8:30 in the morning. And you can appear via Zoom or in person in court, okay? If you appear via Zoom, we'll need you to have video and be in an appropriate position to proceed with the court proceeding, okay? When you leave here, you'll go down 1 floor to the 5th floor to meet with our probation department so they can get you set up for your pre-sentence interview. Do you have any questions? 5th floor.
Your Honor, and I just want to make sure I heard correctly, 12/7 at 8:30.
Yes.
Thank you so much.
Any any additional matters for the record today?
No, Your Honor.
I would briefly ask Judge if you would consider removing the GPS tether at this point. Mr. Geedy has made it to his court appearances. There's been no reports of any violations at this time. It is a bit of a financial burden for him, so we'd ask for that removal.
I have no objection, Your Honor. I'll leave that to the court's discretion.
See where GPS tether is moving. Okay, I can see it there. It's not on the order, it's in the final one. There we go. Okay, we'll remove the GPS tether. All other bond conditions will continue.
Thank you, Your Honor.
No problem. Any additional matters?
No, Judge, thank you.
Thank you. You're all set. Okay, on the record in the matter, the people of the state of Michigan versus Crystal Bolden, file number 22-02912. Council appearance.
Thank you, Your Honor. Melanie Smith appearing on behalf of the people of the state of Michigan.
And please the court, David B. Carter Jr. on behalf of Ms. Crystal Bolden, who is present standing at council table.
Let's leave up the report. This is the date and time set for a preliminary examination. This is another no contest plea, correct?
That's correct, Your Honor.
Okay.
Same report.
Co-defendant case. Okay, and let's see. The plea offer here is for the defendant to plead no contest to amended count 1 of interfering with the police investigation under MCL 750.483A4A. That's a misdemeanor, maximum penalty 1 year and or $1,000 in fines. There is a killer rule, which is a sentencing agreement of no additional upfront jail, probation sentence with dismissal upon successful completion of probation, delayed sentencing. Is that accurate?
It is, Your Honor.
You want to accept that today? Can you speak up so we can hear you? Yes. Okay. Advice and rights and plea information sheet. Is that your signature? Yes. Okay, you put October 19th. Can I put 2023 on there for you? Okay, did you read this document? Yes. You understand all the rights here? Yes. Okay, do you have any questions about any of these rights? No. Okay, did you make these check marks? It sounds, looks thorough, that's all I'm asking.
I normally, when I go through advice rights, I check off each count.
Make sure this is thorough, so some things were underlined, some things were circled. So you understand all of the rights here? Yes. And all the rights that you have to give up in order to enter a no contest plea? Yes. Okay, is anybody threatening you to give up these rights? Yes. Any promises being made to you to give them up? No. So you understand that you would be giving up your right to have a trial. You have the right to jury trial. You have the right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require the prosecution to prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You have the right to see, hear, or question any other witnesses called against you. You have the right to call your own witnesses or present evidence that you believe further a defense to the charge being brought against you. You have the right to remain silent at trial and not have silence be used against you. You want to give up each of those rights, correct? Yes. Okay, you're currently on probation or parole? No. You understand that a no contest plea could potentially result in a conviction that could be public on your record, or you may need to report that to your current employer or future employer. Yes. You're looking at your attorney. I said
She-
could.
She looked at me because what I explained to her is if she's successful under these terms, that delayed sentences would be dismissed. However, if she messes up, it could go into. And I think that's what the judge was stating, but in a different.
I said could, and he said if. Operative words there. So it could potentially end up that way if you're not successful, or if you continue to violate or whatever. That could cause this plea deal that you have to fall and crumble. And this could end up being a conviction that's public on your record. You understand that?
Yes.
It also could end up being a conviction that impacts your ability to get immigration status somewhere or travel. You understand that?
Yes.
Okay. Again, I have police report number 225191165 from the Lansing Police Department, indicating on or about December 9th, 2022. In the area of 5705 South Martin Luther King Boulevard, City of Lansing, Ingham County, State of Michigan. Officer Jack Lindman took a report of abuse having taken place from a victim of the age of 7 years old. Victim indicated, or principal indicated that she asked the victim why he was sad earlier that morning, and he replied, because of this, and pulled his arm out of his left shirt sleeve. There were 3 red contusions on his forearm. All of them appeared to have been made by some sort of an object. They were all the same size and shape, and faint dark blue bruising around the edges. The victim was hesitant to elaborate and stated he did not want CPS called. He stated that his mother has told him that if he calls CPS ever again, she will beat his ass. The principal asked the victim who caused the marks to the arm, and he stated, Allie. Officer confirmed with the victim that Allie is the mother's boyfriend. However, the victim considers him a stepfather because his own father is in prison.
Yeah, if I could, I think that satisfies the factual basis for the initial charged offense. And then-
The issue is that nothing there says who the mother's name is.
Oh.
That was the only issue I was looking for.
We would stipulate that
Okay, and so
the
there's no
mother was the one who.
stipulation is that the mother is Crystal Bolton, correct?
Right.
Okay, and as to that, you plead no contest? Okay, any additional factual basis?
Oh, I figured. Nothing further, Your Honor.
Nothing.
Okay, I find the reason for no contest plea to be appropriate, and I'll accept your plea, find to be made freely, voluntarily, and intelligently, and find you guilty by way of no contest plea. Here. There will be a referral for her to meet with probation before her sentencing date. For the same building.
I'm in a trial on the 7th. I overheard the.
We don't need to worry about that, because that's the sentence her first. We just need the sentence.
So is he free on the 15th?
Are you free on the 15th?
I have a prelim out in 55th A that say 3 defendant prelim. I could be here in the afternoon. Your Honor, I could be here if I'm the first case that day. I could probably make it over to 55 days. As we know, prelims never go right.
You can appear via Zoom.
Okay, that'll work.
The 15th at 8:30. This is 15 at 8:30. Here, when you leave here today, ma'am, you need to go down one floor to meet with our probation department. They can get you checked in for your pre-sentence report, okay? Do you have any questions?
I have one request.
I already know what it is. No contact order.
Yes, being lifted on the child. This is a case that this happened back in December. My client had been participating in services with CPS. Matter of fact, the CPS supervisor's here today. I've interviewed her. She has no concerns with the safety of the house. They have a safety plan in place. One of the things that the prosecutor wanted my client to do during this interim is to do parenting classes. And I found out that she has signed up for those already. She's taking this serious and she's trying to address the issues in the home. Again, it's been 10 months since this has occurred. I don't believe that there's an issue with safety of the minor child. And I think it's in the minor child's best interest that the family start to heal and breathe.
Your Honor, I think it's great that she signed up for parenting classes. I would like for that to at least be initiated and undergoing before there starts to be contact. If Your Honor is inclined to modify in any way at this time, although I'm still asking for it to be held till sentencing, I would just request that the contact be supervised.
Obviously, I think they've been, the supervisors here, they've been doing everything possible. I don't think supervising is necessary in this situation.
My record reflects that the child is in the custody of the grandmother.
That's correct, Your Honor.
Okay. Grandmother is your mother? Is that a yes?
Yes.
Okay. Did you just go to Tabernacle of David?
Yes.
Oh, okay. I know your mother.
And I want to clarify, we're not asking that it have to be supervised by the department or any third party entity. We would be fine with Ms. Bolden's mother being the supervisor if she's willing to do that, which I'm sure she is.
Okay, and she's already engaged with Child Protective Services.
And she has, yes, and she
I
has
think
been.
your
Since,
witness is raising their hand.
that is the supervisor from CPS.
Okay, sounds good. And how long has she been engaging with CPS?
Since I believe, is it December or November? December.
Of last year?
Yes.
Okay. I'll lift the no contact order and she'll be ordered to have peaceful contact with the minor child.
Thank you.
I'm sorry, to have what contact?
Peaceful. Any additional matters for the record?
Your Honor, just to reiterate that the no contact order is only removed for Ms. Bolden and not for Mr. Guillet, so he would not be able to be in the home, correct?
That's correct.
Thank you, Your Honor.
Any additional matters?
No, Your Honor, thank you.
No, Your Honor, thank you.
You're all set.
Thank you, Your Honor. Have a nice weekend.
Same to you. Okay, Mr. Abbott, can we have Calvin downstairs? Did you need something from me, Mr. Bach?
I just got.
Oh, I was
I don't know if he's down there. He's supposed to be.
Ms. Donnelly had someone down there.
She wasn't here. I believe she knows how to proceed. I don't know where she went.
No, I know. I said she had somebody downstairs.
Yeah.
She told me she was ready on hers, but we need to bring him up when she's ready. And then let's see if Mr. Cowden. Are we running that? Okay, I think Ms. Donnelly's not running Clarkville.
No.
Okay, so we can bring them both up.
Will not be running that one. We also have Mr. Flowers Taylor.
Flowers Taylor's gonna run too?
Yes, I believe he's run.
Goes.
Okay, which one do you want to go with first, Mr. Abbott?
I will, my anticipation on Cowden, Your Honors, I will be asking for an adjournment of the PE as I have I'll just say I have found in a cursory search of the jail system, additional contacts since the no contact order was amended, and I have contacted LTE.
Okay.
Or I should say additional attempts at contact. And I
Phone
have
calls, is
LTE
you
looking
talking
at-
about jail calls?
I have,
Is that, are you talking, I just want to know if you're talking about jail calls.
I have e-messages and video visits here.
Okay, sounds good. We can bring up Cowden,
And I have.
and then if we can find Miss Donnelly, we'll bring up Clark. On the record, in the matter of the people of the state of Michigan versus Darren Clark, file number 23-03033, council appearance.
Jeff Brattos on behalf of the people, Your Honor.
Assistant Public Defender Sarah Donnelly on behalf of the defendant Darren Clark, who is present standing to my right.
How are you, Mr. Clark? Today is the date and the time that was set for a preliminary examination. Last week, there was an offer extended that counsel you advised your client was considering. How do you want to proceed at this time?
Your Honor, we would like additional time to consider the offer, well, both defense and the prosecutor. They can't, the prosecutor couldn't make a Killebrew agreement at this time because of the Calhoun County case. Also, if he is to, given what might happen in Calhoun County, we might want to adjust what he's being pled to, considering he's on felony probation in Calhoun County. So it just might change it up. So at this time, we would be requesting, or he would be waiving his timeline, and we'd be requesting a personal recognizance bond.
Okay. Is that correct? You want to waive your timeline because you have the right to have a preliminary examination within 21 days of the date of your arraignment. Okay, so you want to waive that so this can be reset? Okay, anybody threatening you to get you to waive the timeline? Okay. How much time do you need?
Your Honor, if he is released to Calhoun County, I imagine he'll be arraigned and given court date shortly in that manner. We just kind of want to see it, get a feel for what they would do. So I no more than 30 days.
November 22nd. November 22nd at 8:30. Bond is amended to 5,000 personal recognizance with all previous bond conditions still in place. So that is it, including 48-hour report to pretrial services. You will test weekly while out of custody, okay? Do you have any questions?
Do you have any questions?
Any additional matters?
No, Your Honor.
No, nothing from the people, sir.
You're all set. Okay, we're on the record in the matter of the people of the state of Michigan versus Zachary Cowden. File number is 23-01265, and I have 23-02982. Council appearance.
Jeff Brattos on behalf of the people, Your Honor.
Good morning, Your Honor. John Adam representing Mr. Cowden. He's seated in his wheelchair.
Okay, today was the date and the time set for a preliminary examination. I also have another file here that has a bond show cause violation, it looks like, and a P53 contempt, which is a bond violation. I don't see where he was arraigned, but this looks like it's an old police report. It was the police report from June, alleging that he violated no contact order. I'm not sure if he was arraigned on this or not, because there's no note indicating, but I will say here again, I have a police report indicating that there's an allegation that you, back on June 30th, 2023, violated the terms of your bond by violating the no contact order with the alleged victim. You would have the right to have a contested hearing, and you would have the right to be represented by counsel at that hearing. And if you're found guilty, you would have you will be subject to possible penalty for contempt of court of 93 days in jail and or $7,500 in fines. Do you understand that, sir?
Yes, ma'am.
Okay, he's entering a plea of not guilty on the bond violation.
Yes, thank you, Your Honor.
So we'll set that for a hearing. Okay, and then as to the other two matters which are set for a preliminary examination, how are we proceeding?
At this time, Your Honor, the people were ready to proceed on the preliminary exam. However, people would have been asking for an adjournment in that matter. However, after conversations in chambers, I believe defense has some, or I should say, there is a case between the victim in this case and the defendant where their roles are reversed out in Kent County, and there is some risk of self-incrimination in this matter. And so in order to have an attorney present for the victim as she testifies, this would be asking for an adjournment at this time, Your Honor.
There's two separate victims on these files, correct?
Yes, sir.
Okay, which victim are we talking about?
It would be the victim of the domestic violence, Ms. Mackenzie Melton.
I say they both have a domestic violence, okay. So file number 23-02982.
Yes, sorry, yes, 2982, Your Honor.
Okay.
The one scheduled for preliminary exam.
Okay, and so that victim has another case involving this defendant and the roles reversed.
Yes.
Okay. Okay, so the concern is protection of that victim's rights as it relates to the criminal matter that's pending.
Yes, Your Honor.
The victim is present in the courtroom?
Yes, she is, Your Honor.
Okay. Ma'am, what's your name? Okay, and so, Ms. Melton, because you have a pending criminal matter involving this same defendant, you have the right to be represented by an attorney or have representation here if you're going to take the stand under oath. Reason being is that anything you say can and would likely be used against you. So you have the right, again, according to the Fifth Amendment, against self-incrimination, okay? Okay, so my inclination and concern is to make sure you're represented if you're going to take the stand. You have an attorney in that matter? Okay, well, I need your attorney to appear then before you can testify, okay? So that you have someone here to make the proper objection when it's time to protect your Fifth Amendment right, okay? Yep. December 15th at 8:30 will be the new date.
November 15th, Your Honor?
December?
Oh, December. Okay.
Correct, or, yeah, because you said that the matter in Kent County is when?
The next scheduled date on the matter in Kent County is November 20th.
Okay. So, put the- here, you can be in the same- That's correct.
Set for you on the 15th.
8:30. Okay, and then the other matter, we have the victim here on that.
Is that the bond violation in 23-1265 or the bond hearing?
Correct.
Yes, both complaining victims are here in that matter, Your Honor.
Okay, my record here says that this is set for a preliminary examination. In that file.
My docket, Your Honor.
I didn't realize that. Mr. Bond.
That is
Yes.
PE 10/19/23 at 9 a.m. Whose camera is that? Submission. I don't know. It's someone, it looks like a clerk's office initial. Set it for a hearing, or prelim today. At least according to this. And there is a notice in the file. This was set for exam today.
Your Honor, I think this is a continuation of an exam that was started in May, on the 11th of May.
Okay. Are we ready to continue with the exam?
Not at this time, Your Honor, as I don't believe either Mr. Abbott or I were aware that this was scheduled for today.
So Abbott looks like he's ready to continue though.
If you are.
I mean, at this time, I also know from the notes in my file, Your Honor, that there was an investigation being done by LPD into potential new charges on that case. And since that case, since the defendant failed to appear for the continuation of that, the detective who was on that file has since retired. In conversations with LPD about the new filing, which would be 23-02982FY, I did ask the detective that was assigned to that one to also bring himself up to speed on the investigation that was done in 23-01265FY.
Okay, wait a minute, just so that's clear. Is this a third file?
No.
I don't know. What was the file number that you just called out?
23-01265.
That must be the one I just gave you. 26.
23-01265.
Okay, that's this file. Okay.
Yes.
Got it.
And so at this time, I guess the people would be requesting an adjournment of that one. Would ask, I guess, that it be set for the same time as the adjourned preliminary exam in 23-02982. Your Honor, so that one day can be set and they can both be handled at the same time.
Oh, so there's going to be a new detective assigned on this one?
There has already been a new detective assigned, Your Honor, and he is he's been made aware and asked to bring himself up to speed on the investigation that was done by the previous detective.
Investigation of
I
jail
believe,
calls?
yes, I believe it was communication with one of the victims in violation of the no contact order and potential witness interference, Your Honor.
Okay, sounds good. I'll note that and I will reset this to the same date as the other matter, which is December 15th at 8:30. Any other matters?
Your Honor, just to be clear, there's no witness interference charges in 23-1265.
No.
This is for officer witness to appear. What was the officer appearing for? I did see where I adjourned this for that.
Yes, the officer was going to appear, I believe, for additional testimony as to the charges on the complaint. And then there was, through a search of, based on the notes from the preceding prosecutor, there was potential witness interference that was found. LPD was doing an investigation into that, and it would be the testimony of the detective that would lay the basis for potential new charges, Your Honor.
Okay, but as to
They had not been
the
added.
underlying charges, what officer witness is appearing for that?
That I am not 100% sure on, Your Honor. I believe. As I stated, I don't believe this was scheduled. I either of our assistants for preliminary exams, so I don't believe the officer was subpoenaed for today.
I'm trying to understand how we start something in May. Oh, did he fail to appear? Is that what happened?
Yes.
He failed to appear, that's why.
And Your Honor, on that case, the officers who were subpoenaed, the officers who were subpoenaed were Officer Jamil Bakri and Officer Jacob Ellis.
Okay, sounds good. So that clarifies there is some allegation of.
So Bakri and Ellis are going to be
As well
subpoenaed
as,
for the next hearing.
sorry, there was a second page, as well as Officer Brent Trasky. And I would expect also testimony from Detective Jeremiah Wanaka as well, Your Honor.
Okay, thank you. That sounds good.
Sounds good. Okay. Any additional matters for today's record?
Not on, from people not on file 2301265, Your Honor.
Well, I've already asked any additional questions on the other file.
My apologies, I wasn't sure what order we were handling this.
Okay, yeah, we're on, right now, we're on 23-01265.
Nothing on from the people on that file, Your Honor.
Well, as far as the file itself goes, nothing, Your Honor. Only my client's health condition is on my mind. At some point, I'd like to address that with the court.
Okay,
Now it's good.
now it's better.
All right, so he's suffered substantial injuries to his leg. It's held together with some pins and bolts and steel stuff, which are all damaged apparently as a result of, I'm not sure why, but he's suffering a lot of pain. He's lost motor control, muscle control of his thigh and his foot. His foot is purple.
It's purple.
That's what he says. And
Oh, you can't see it, he just told you that?
yes, Your Honor,
Got
and
it.
it's wrapped up in a boot to keep it immobilized, so
Got
I
it.
didn't ask him to show it. However, you know, he hasn't received any medical attention since he arrived at the jail. I have emailed the commander of the jail and I received no response. I know he's kited from where he is to try to get some help. He's been seen by no doctors at all. And I asked the court, well, one, if you have any ideas of how to solve the problem, and two, if he can't be seen in jail, couldn't we bond him out to go to the hospital?
Yeah, he has a bond, $20,000 cash surety. He can post a bond and then he can go to the hospital.
He doesn't have
Well,
20,000.
bonds are set based on the potential threat to victims and the public and flight risk. And here we have all of the above.
I don't know if the court or whoever it was that set the bond took into consideration in terms of risk to the community, the fact that he's
Risk to whom?
risk to the community and to the victims.
You don't think they took that into consideration?
I don't know. Were they aware that he's nearly immobilized completely by this injury to his legs?
I don't know. I wasn't present. You want me to speculate as to what they were aware
No,
of?
I'd be asking the court to take that into consideration now when you're assessing his risk to the victims.
Well,
How's he gonna hurt
the
anybody?
allegation,
How's he
well,
walk?
the allegation was an assault with a firearm. You can do that from a wheelchair.
Fair enough.
I don't know. You kited it, and did you get a response to the kite?
They told me that they understand my situation, that it's gonna take multiple weeks to process and everything else. I've been in there since September 30th. I've asked them if they asked for my medical records from my surgeon and my doctors, and they said they have. I've had my people get a hold of my surgeon from in the world. My surgeon has not heard nothing from the county jail. I'm not allowed to put no pressure on my leg at all. As of right now, I have 4 pins and a plate bulging out of my shin due to when I was arrested. They yanked me out of the truck before they knew my condition. And then one of the arresting officers tried to pull me from the passenger side through the driver's side vehicle to pull me in to be able to shut the door, and he caught the bottom of my boot on the hard seat and kept pulling until my leg was able to pop up and be released.
Okay, so your position or your belief is that during being taken into custody, was it on this warrant or another warrant?
On this one.
Okay, that you potentially exacerbated a pre-existing injury, is that what you're saying?
Due to my accident, I had my hip broke, my femur snapped in half, my knee completely shattered, my tibia was snapped in half, and my ankle was also broke at the same time on my whole left leg. Due to that, I also suffered a sprained ankle, dislocated ankle, and a sprain at the same time, along with my ACL and my MCL in my knee was torn.
Okay, when did you kite medical?
I kited them on, I think it was the day after I seen them, so it would have been the 4th, the 16th, the 17th, and I believe every time that I'd seen the withdrawal cart, because of the doctors for my pain meds had me in oxys, every time I seen the withdrawal cart, I let them know that my leg, that I couldn't feel, that I can't feel it. I can't feel my ankle, my foot, or anything.
Are you on pain medication now?
They're giving me 600 milligrams of, I think it's Motrin.
Okay.
That's it.
Okay, and you saw a medical, you just didn't see a doctor, is what you're saying?
I seen the main provider. The only thing he asked me was a bunch of medical questions about if I smoked, if I drank, anything like that. And they gave me a TB test and that was it.
Okay, but you didn't see one in reference to what you're alleging to be an injury on your foot, or was it your leg?
My whole leg.
Your whole leg, okay. But you didn't see a doctor for that?
No.
Did you see a nurse for that?
No, I've asked multiple times, and the answers that I keep getting back are, it takes time, it takes time. I've been in there for 3 weeks now, and I still haven't seen nobody.
Okay, the court will contact the jail to find out the status of your kite for medical. Because I believe that the bond that's set is more than appropriate. Let's see. Actually, I don't know if we have a bond right now. Do we have a bond right now? We had a 20,000 cash surety before. He remanded. Okay, so he had a 20,000 cash surety bond, which he posted and then didn't appear. So he's remanded right now without a bond.
Without bond on 1265.
Well, if you could post a $20,000 bond and not appear, that is in and of itself concerning. I think that's why this matter is set for a show cause. Is that correct?
Pardon me, Your Honor.
That was why this was set for a bond show cause, I believe.
Originally, yes. That was the one he missed through his motorcycle, bike accident.
I don't know why he missed court back in May. There's a bond on this one. This one, there was no bond because he was remanded on benchmark. I'll issue a bond of $20,000 cash surety with GPS tether. No contact order will continue. Then we'll follow up with the jail while he works on trying to post the bond to see what's taking so long to get him seen by a doctor. Any additional matters for the record?
Not on that file, Your Honor. I would like to go back on the record briefly on the other file.
No problem. Back on the record. And the accounting matter, file number 23-02982. Which you need on this.
Yes, Your Honor. As this kind of went along with why I waited was it sort of went along with how the show cause would go on the prior file. The people would just ask that while Mr. Cowden remains in the Ingham County Jail, that his communication privileges be revoked, Your Honor. If Your Honor recalls back when we were here on Friday, I believe that was October 13th, Your Honor amended the defendant's pretrial release order to include no contact directly or indirectly with the victim, Kylie Mole. Since that time, Your Honor, during just a cursory search of the jail system, the people have found, and I have a copy for Your Honor if you'd like to see it, 2 messages from the account of Zachary Cowden to the account of Kylie Mole that were sent on October 16th, and then also video visits from the account of Zachary Cowden to the account of Kylie Mole that are dated between October 15th and October 17th, Your Honor. Permission to approach?
Yes. Mr. Abbott.
So give me copies of these messages.
For the record, Your Honor, I have turned these over to the Lansing Police Department to do an investigation.
Mr. Abbott.
Thank you, Your Honor. Spoke with Mr. Cowden. He says those messages were intended for someone else, someone named Kiara Lane. It was not his intention to send them to Kylie or Kitty Mom.
What does it mean recipient deleted? What does that mean? Do you know?
I am not sure, Your Honor. I would assume that means that whoever received the message deleted it after they received it.
Okay, well, I remember distinctively back on October 13th, the prosecutor making a request for me to amend or to revoke or restrict Mr. Cowden's phone privileges while in custody due to the allegations that he was violating the no contact order. I stated clearly on the record that I would not revoke them because he had not been told that he couldn't have contact with Kylie Moe, but that I would amend the bond then to include Kylie Moe. I should also note that Kylie Moe ended up in my virtual courtroom thereafter, asking me why she was having a no contact order with her fiance. I told her to contact contact the prosecutor's office. Now I have an allegation. Allegedly, 3 days after I made that statement of communication, why the fuck is what I asked for and said last fucking night not done? Yo, shit is starting to piss me off, and I'm really starting to lose a lot of interest in all of this shit. That was at 12:07 p.m. Allegedly, from Mr. Cowden's account, again to Kylie Moe, same day, about 19 minutes later. Why the fuck are you doing you? Told you to put money in my account or on the phone. So I don't know what the F, I'm losing a lot of effing interest in this whole thing on how now I probably just got a bond restricted because of this stupid ass shit. I hope you happy. If I were to believe this, I would completely believe it was sent to the person that he was told not to talk to, because he indicates in this allegedly that he probably just got a bond restricted because of this.
Due to a message to Mackenzie Mountain that I didn't need to send to her before the.
You have the right to remain silent. Anything you say and put in writing can be used against you. I'm going to amend this bond in this file to 20,000 cash surety. It was 5,000, 10%. Someone struggles with following court orders. And I'm going to revoke your phone privileges entirely, except for calls to your attorney while in custody. Any additional matters?
Nothing.
That will also include sending e-messages and visits.
Nothing from the people, Your Honor.
Thank you.
Nothing from the defense.
Thank you. And so, can we bring up flowers, Taylor, if we're allowed?
Right there.
You can be seated. In the matter of the people of the state of Michigan versus Rajay Flowers Taylor, file number 23-02687 FY. Appearance, please.
Rodowitz on behalf of the people, Your Honor.
Good afternoon, Your Honor. John Abbott, representing Mr. Flowers Taylor. He's seated to my right.
Okay, and so we're ready to proceed to exam. Is there any preliminary matters?
Nothing from the people, Your Honor. The people are ready to proceed.
We're ready to proceed, Your Honor.
Okay, call your first witness.
Thank you, Your Honor. The people would call Officer Adam Walter.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am, I do.
You can have a seat. Please state your first and last name as well, both.
Adam Walter, ADAN, last is Walter, WALTER.
You can proceed, Counselor.
Thank you, Your Honor. Good morning, Officer Walter.
Morning.
Officer Walter, how are you employed?
The City of Lansing Police Department,
Right, and how long have you been an officer with the City of Lansing?
just over 7 years.
All right, and were you working in that capacity on August 30th, 2023?
I was,
All right, and how were you dressed that day?
and my police uniform.
Did there come a point in time that day when your duties took you to 3915 Windermere?
Yes, sir, it was.
And is that located in the City of Lansing, in Ingham County?
Yes, sir, technically in Eaton County, but yes, sir.
Okay, and is that within, to the best of your knowledge, is that within 1 mile of the county line there?
Yes, sir.
Okay. And why were you dispatched to that location?
I was dispatched there for what we call a trouble subject. Someone was trying to bang on a house, bang on a door inside of the house. So I was dispatched.
Okay, and when you arrived at that location, did you come into contact with anyone?
Eventually I did inside the residence, yes.
And who did you come into contact with?
I came in contact with Miss Kelly and Mr. Flowers Taylor.
Okay, and Miss Kelly, do you remember her first name?
I believe it's Daniela.
Okay. Can you describe Miss Daniela Kelly's demeanor when you arrived there?
Yeah, she was very upset when I had it with her inside the residence.
Your Honor, I believe the complaint says arrived, and I asked for a sequestration.
Okay. Were you proceeding under 27C?
That was the plan, Your Honor, as I did not know where the victim had gone,
Okay,
but
do you
obviously
need
she has.
an adjournment to talk to her, or a recess, or you want?
No, thank you, Your Honor. I think I can, I'll call Miss Kelly next.
Okay, Ms. Kelly, can I just have you step right outside this courtroom while this witness testifies, okay? A sequestration order is granted. You can continue.
Thank you. What did you observe when you arrived at 3915 Windermere?
At first, we checked around the residence for anybody that was outside. So original call was about someone being outside the residence. I ran able to locate anybody, so I went to the front door. At which time I was at the front door with my partner, Officer Corey Brooks, and a child that came to a window, I believe, and she was talking to the child for a minute. I was knocking on the front door, and through a small window, that's when I saw a male subject in the back of the residence in the bedroom for a brief moment, and he walked back into the bedroom where I couldn't see him anymore.
Okay. And you stated prior, and I believe that was the question I was in the middle of, is can you, did you eventually get into that residence?
I did.
All right, and you encountered Miss Kelly in that residence, correct?
I did.
And can you describe her demeanor when you encountered her?
Oh yeah, she was upset and just pretty frightened.
Okay. No other questions at this time, Your Honor.
Oh, Kristen.
Okay.
Okay, this witness can be excused or.
Sorry, one final question, Your Honor. If I may, sorry. I
Okay.
just thought about- Did you, you said you saw a male subject in the house, correct?
Yes, sir.
And do you see that subject here in the courtroom today?
Yes, sir.
And can you identify where they're sitting and an article of clothing they're wearing?
There's a gentleman sitting next to this gentleman in the suit, and he's wearing a button-up blue shirt.
Please let the record reflect the witness has identified the defendant.
Any objection to identification?
I have one here.
Okay.
The testimony a moment ago was that you just saw him kind of flash past and peek out and then disappeared.
Yes, sir.
And how far away was he?
I would say he was probably about to the end of the house, so probably approximately 20 yards.
And were the lights on in the house?
No, sir, it was daytime.
Okay. So you're looking through a little window and you saw a person for a couple of seconds?
Yes, sir.
You're quite certain that this is the person you saw?
Yes, sir.
Did you see him again that day?
Yes, sir.
So is your identification of him based on that contact as much as it is peeking through the window?
Yes, sir.
Thank you, nothing from you.
Any objection?
No.
Identification is noted.
No further questions at this time.
Thank you. Cross exam. Okay, thank you, Officer Walton.
Yeah.
And you can call your next witness.
All right, thank you, Your Honor. People would call Miss Daniela Kelly. Yeah.
Come right up here. Then when you get to the stair, you'll stop and raise your right hand. Raise your right hand, face me. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
Okay, you can have a seat. So there's a microphone that is in front of you, and the lady behind you is my court recorder. Her job is to take down everything being stated in the court, so your responses must be loud and clear. They must be verbal responses. We can't do head nods and shakes or uhs and ahs, okay? And then if there's an objection made by the attorneys, you would stop speaking. I'll make a ruling on that objection, and then I will let you know if you can give that answer or not. Can you first state your first and last name and then spell them both?
My first and last name is Danielle Kelly, spelled Danyelle. Last name Kelly, Kelley.
Thank you. Good afternoon, Ms. Kelly. Ms. Kelly, do you know an individual by the name of Rajay Flowers Taylor?
Yes.
And how do you know?
He's my ex-boyfriend.
You say he's your ex-boyfriend. How long did you two date?
Since January.
And then January of what year?
2023.
All right. And when did that relationship end?
There was a situation that happened in February. We're no longer together, but he was still living there because his parole officer had okayed the house for him to live there.
Okay. And when you say he was okay to live in the house, what address is that?
3915 Windermere Drive.
All right. Okay, that's located in the city of Lansing?
Yes.
And is that located in Ingham County or Eaton County?
It says Eaton, so when you call the police, they directly to Ingham. So.
Okay. How far, I guess, I don't scratch that. And who owns that residence?
My landlord, Albert.
Okay. So Ms. Kelly, I want to bring you back to August 30th of 2023. Were you at 3915 Windermere on that date?
Yes.
And do you remember that date?
Yes.
Why do you remember it?
because it was very traumatic.
Okay. And on that date, was Mr. Flowers Taylor living at that address at that time?
No, he was not.
And why was he not living there?
Because the night prior, we had broken up and I dropped him off at his mom's house.
Okay. And that night when you dropped him off from his mother at his mother's house, did he take his belongings with him?
He didn't really have much there. So he just had on whatever he had on again. He wanted to come back the next day to gather the little bit of stuff that he did have there.
Okay. And that night you dropped him off at his mother's. Did you hear from him again that night?
Yes.
Was that, how did you hear from him? Like what method of
He
communication?
constantly called me and sent me text messages.
And what was he saying to you that? And this would, sorry, back up a second. When you took him to his mother's house, would that be, what date was that?
That was August 29th.
Okay. So it's the night of August 29th. What was he saying that night?
He was saying a lot. He was threatening to kill me and my kids over the phone. He was telling me that I did everything was a game and that.
So, Your Honor, it's a narrative. It's not a specific question.
Did you want to respond to the objection?
No, Your Honor, I'll move on.
Okay, objection sustained.
Okay. So Ms. Kelly, how did the events of August 30th start?
So it started actually August 29th. Actually the day before we had agreed to become a couple again.
Your Honor, again, another narrative.
Yeah, okay, I'll rephrase, Your Honor.
Oh, thank you.
Did Mr. Flowers Taylor return to your residence on August 30th?
Yeah.
What was the first thing he did when he showed back up at your residence?
He was knocking on the door. He had texted me prior and stated that he wanted his belongings and he had bought my kids and stuff and he wanted those back as well. And so I had stated to him that it would be a quick handoff because I was at work from home. I was at work.
Okay, and did you ever open the door for Mr. Flowers Taylor at that time?
No, because when I went to hand him the stuff, I had noticed that he had money.
Okay. And so after you didn't open the door, what happened after that?
I had called the police and I was telling them that someone was at my door and that they were threatening to come. He was alternating between walking from my front door to my back window, and then gave me a shovel on the back window with a plastic shovel, and then he would go back to the front.
Okay, and did Mr. Flowers Taylor ever gain entry into your residence?
Yes.
How did he do that?
So the door of my residence was kind of, if you push hard enough, like really hard enough, it could open. And he pushed it open really hard.
Okay. And so after Mr. Flowers Taylor got into the house, what happened after that?
After that, he came to my back room and he had a knife in his hand. He was threatening me. I was trying to hand him the things that I had packed up for him, and he was telling me he didn't want it. And he was just being very aggressive.
Can you speak louder?
He was just being very aggressive.
Okay, and just to back up a little bit, because I kind of lost you there for a second, you said something about his hand. Can you restate
Yeah,
that?
so he had the knife and I was facing him this way and he was facing me. So he had it in the mirror hand, like the same hand as this.
Okay, and so would you say that was his left or his right?
It's like the same hand you would have in your, like the pen. It's right here.
Okay. And can you describe the knife that you saw Mr. Flowers Taylor have that day?
Yes, it was a gray handle, not a gray handle, it was a gray blade with a blue handle.
Okay, and when you say he had a knife, was this can you describe, I guess, the type of action of the knife? And if you need me to explain that a little more, I can.
Actually, it was just held out like this.
I guess, let me back up in there. Was this a knife that, did the blade fold in? Did it have a sheath? Did
Yeah, it folded in. I believe it folded in.
Okay, and when he approached you at this time, was the blade in or out?
The blade was out.
Okay. And how did you feel at this time?
I did feel kind of scared because he had been blowing my phone up and threatening, and I don't know if he would have done anything or not. And he was saying things that would suggest that he would harm me and my son was up there. He would also harm my son. So I was trying to be calm and cool as possible.
Okay. And so you're standing there, I believe it was in the same, you're sitting in the same room as Mr. Flowers Taylor. He has the knife out. What does he do at this point?
He's talking a lot and he's holding the knife out. And he's telling me that, okay, so back up. I had, before he busted open, I was on the phone with my brother. And him and my brother was.
Objection, Your Honor, further narrative storytelling.
Yeah, again, I can move on. While you were in the same room with Mr. Flowers Taylor, did he ever touch you with the knife?
Yes, it was like more so he would take the blade and he would run it across like my arm or like my clothing, but not like more like in a, I don't even know how to describe it. I don't even want to call it playful, but he would run the blade against my arm and on my clothing.
And was he saying anything at this time?
Yes, it was a lot. Just the same things that I broke apart and that I was on pay for it and I think it was in the game.
If you could keep your voice up.
Okay.
How did you feel when he was running the knife along your body to describe?
I was frightened because I didn't know if he was going to make a movement because he had also made like sticky movement because I was back in a corner, so I had no control.
Okay. And then what happened after he was running the knife along your body?
He just continued to talk. My son had was asking me a question around the same time he was asking me a question. And my son was asking me if he could open the door because someone had knocked on the door. And so I said yes.
And can you describe Mr. Flowers Taylor demeanor when there was the knocking on the door?
He had told me that it better not be the police or he was stab me. Because my son had to go and take open the door, so he ran to open the door.
And was Mr. Flowers Taylor with you the whole time that was going on?
Yes, once the police came in, they asked me if I was okay, and I had dispatched him and ran out to them, I told them no. And that's when he came out as well, and they started asking him questions. Yeah, very irate with them.
And during this incident, did he ever leave the bedroom at any point to see who was at the door?
You mean after I ran out?
No, prior to your son opening the door.
No.
Okay.
He just started knocking, and he told me that it's not the police.
Okay. So, Ms. Kelly, I'm going to show you what has been marked as People's Proposed Exhibit 1. If you could just take a look at this really quick and then look up what you've done. Permission to approach her.
Yes.
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 And do you recognize that picture?
Yes.
And how do you recognize it?
Because I was the one who was there.
Okay, and is that a fair and accurate representation of the knife that he had on that day?
Yes.
Okay, at this time, Your Honor, people would move for admission of People's Proposed Exhibit 1.
Any objections to people 1?
No, Your Honor.
People 1 is admitted.
Permission to approach and publish to the court, Your Honor.
Yes.
Now, finally, Ms. Kelly, I just need to ask, do you see Mr. Flowers Taylor anywhere here in the courtroom today?
Yes.
Can you just please, for the court, indicate where he's sitting and an article of clothing he's wearing?
Sweater.
And where is he sitting?
I didn't hear what you said.
So, can you say that, repeat that again? What's he wearing?
He's wearing a blue sweater.
And where is he sitting? Please let the record reflect the witness has identified the defendant.
Any objections to identification?
No, Your Honor, she pointed at it.
No further questions, Your Honor.
Cross-examination.
Afternoon. So, Mr. Flowers Taylor had been living at that address since January
Yes.
and had lived there fairly consistently all that time.
There was a break where he did obtain his own residence. Let me say the end of June.
Okay.
But he ended up coming back.
And came back and he'd been living there right up until the night before this happened.
Yes.
And up until that time, he was welcome to come and go as he pleased. Gentlemen?
Towards the month of June, and he had kind of his own place. We were not really seeing eye to eye, so it was more like we were not welcome over here. But once we got back, good time to welcome.
So when he pushed the door open, was do you feel that he had violated your space, or do you think that that was consistent with the way your relationship had been going?
No, during that time when he pushed the door open, he was not welcome. He stood out. He didn't just push it open right away. He stood there and knocked first.
Okay. And he knew the door was, the lock doesn't work on the door.
It locks, but with the right amount of force, it comes open.
Okay. Has he opened the door that way before?
No.
Have you?
One time I had locked my keys inside the house and the door was locked.
You never actually stabbed you with a knife, no?
No.
And you said you were kind of worried,
Yeah.
but not really serious. You didn't really think he was going to stab you.
Because of his tone, it was jokey but serious at the same time. So I was like, okay, if I can make enough jokes or something that will calm down, but it didn't seem to be working. So then they started to get scared.
Thank you. Nothing.
Redirect.
Nothing from this evening, Your Honor.
Okay, may this witness be excused?
Yes, Your Honor.
Okay, ma'am, there is a sequestration order, so that means that you can't speak to any other witness about your testimony, okay? Okay, you can be excused. Yep, you're free to go. Any additional witnesses?
Yes, Your Honor, the people call Officer Cody Brooks.
Well, counsel approach.
Yeah. No further witnesses, then, Your Honor.
Any defense witnesses?
No, thank you.
Argument.
Yes, thank you, Your Honor. The people would move that this be found over as charged in the complaint to the circuit court. We heard testimony from two witnesses here today, Officer Adam Walter and the victim, Miss Danielle Kelly. We heard testimony from Officer Walter that he responded to the area of, or to the address of 3915 Windermere, City of Lansing, which is technically within Eaton County, but falls within the jurisdiction of the court, as it is within 1 mile of the Ingham-Eaton County line. And he responded there on August 30th, 2023 for a troubled subject. When he arrived there, he says he didn't see anybody outside the house, so he peeked in. He saw a male peek out from a bedroom and then go back into said bedroom. Then when he was able to enter the home, he encountered both the victim, Miss Danielle Kelly, and the defendant, who he positively identified here today. We also heard testimony from the victim, Miss Danielle Kelly, who stated that she had a prior dating relationship with the defendant, Mr. Rajay Flowers Taylor, who she positively identified here in court today. We also heard testimony that on the evening of, on the morning of August 30th, 2023, she was at home at 3915 Windermere in the city of Lansing, and that at that time, Mr. Flowers Taylor had come to her door, knocking on it, asking to be let in. She said that she was, I believe, going to hand him stuff, but that he had a knife, and she got frightened at that point. So she did not let him in the house and instead called police due to his prior conduct. At that point, he proceeded to knock on windows and doors around the house, and then eventually forced entry into the home, where he again pulled out the same knife, possibly identified here by the victim, Miss Kelly, and proceeded to back her in, as she stated, back her into a corner and then run the knife along her skin while saying threatening things to her. She did admit that during this, she initially was not all that frightened, but as it continued, she became frightened that he would actually do something to her or her son. With that, Your Honor, I believe the people have met by probable cause evidence. Count 1, assault with a dangerous weapon, in that Mr. Flowers Taylor did assault the victim here, Miss Kelly, with a knife, and also for count 2, domestic violence, as there was an assault and they had a prior dating relationship. And that would be a third offense notice, Your Honor. And so with that, Your Honor, the people would move that this be bound over as charged to the circuit court.
Mr. Abbott?
Your Honor, as the counsel's noted, she said that she was kind of scared. When it rises, I'll leave that to the court's discretion. It may become a question of fact for a jury eventually, whether or not there was actually any fear there of immediate damage. Thank you.
Thank you. Okay, Mr. Flowers Taylor, today was the date for your preliminary examination. The burden is on the prosecution to establish probable cause. So probable cause is a low burden, sir. It's more than mere suspicion that a crime was committed. And it's based on the facts and circumstances presented at today's hearing and the evidence presented at today's hearing. We had 2 witnesses today. Officer Adam Walter indicated he reported to the address of 3915 Windermere, Eaton County, but within the 1 mile radius of Ingham County, state of Michigan, making venue before this court appropriate. He stated he responded to a call for a troubled subject and that there was someone banging on doors and windows. He identified the person seated next to counsel as the defendant that he stated he saw in the back or in the bedroom of the address located at 3915 Windermere, and that he came in contact with the alleged victim, Danielle Kelly. Danielle Kelly appeared today and testified that the defendant is her former boyfriend, that she's been in a dating relationship seemingly on and off since January 23rd. She stated that there was a situation that happened in February that caused him to break up, but he still lived there due to him being on parole, and I guess parole to that address. She described the incident having occurred on August 30th as something that was a very traumatic event for her. She said that the night prior they had broken up and she had dropped the defendant off at his mother's house, that he had made contact with her. He didn't have much still left at her house, but wanted to come back and gather the remainder of his things. She testified that he called her constantly that evening and sent her numerous messages, and that he threatened to kill her and her children. She said the defendant returned to her address on August 30th, again, banging on the door or knocking on the door. She testified and stated multiple times he was not welcome at that address at that point. She said she did receive a text from the defendant prior to his coming to the door, indicating that he wanted his belongings. She stated that she would, it would be a quick drop off and that she would package his items. She also wanted some things that he purchased or given the children. She indicated that the defendant gained access without her permission by pushing the door open after opening or knocking on the door. She noted that the door is easy to be jarred when you push into it, even indicated that there was a time when she got locked out and she did it herself. She indicated that the defendant came into her bedroom, started yelling at her, that he was very aggressive, that he had a knife in his hand. She described that knife to have a gray blade and a blue handled knife, which at the time that he approached her, she said the blade was out. People admitted Exhibit 1, which is a picture of a knife that fits the description that was provided by the witness, the victim. And she indicated on the record that that was the knife that she saw at the time and date of the alleged incident. She said the defendant was saying things that suggest that he would harm her, and that she was kind of scared. She said that he would take the blade and he would run it across her arm and her clothing. And she was backed in the corner at the time and had no place to go. She went on cross-examination. She was specifically questioned about being kind of scared. She described the defendant's tone to be joking, but then serious at the same time. And at some point, it seemingly either escalated or changed. And I guess that provided her sufficient enough fear that brought us here today. The court ruled for assault with a dangerous weapon would need to be proven beyond a reasonable doubt at trial. And at that time, the prosecution will need to prove first that the defendant either attempted to commit a battery upon Miss Danielle Kelly, or did an act that would cause a reasonable person to fear or apprehend an immediate battery. A battery is a forceful or violent touching of the person or something closely connected with the person. Second, the people would need to prove the defendant either intended to injure Danielle Kelly or make Danielle Kelly reasonably fear an immediate battery. Third, at the time the defendant had the ability to commit the battery, appeared to have the ability or thought he had the ability. And fourth, that the defendant committed the assault with a dangerous weapon. A dangerous weapon is an object that is used in a way that is likely to cause serious physical injury or death. We'll start with the fifth element, whether or not there's a probable cause as to a dangerous weapon. We have a testimony about it, a blade or a knife, and a exhibit that gives a picture of that. I think it's undisputed that a knife is a dangerous weapon. The argument of the defense is that the witness's testimony was that she was kind of scared. The court rule doesn't specify how scared they need to be or how much fear it needs to have. It just says that he either needed to have attempted a battery or did an act that would cause a reasonable person to fear or apprehend an immediate battery. And although she described that altercation or incident to be an incident that caused her to be kind of scared, she also described it as being traumatic. And she also described that at some point he was joking, but then he turned serious at the same time. And so that may or may not have caused some kind of confusion or eerie feeling. I'm not sure. It sounds like it's a question of fact for the jury. So with that being stated, the court is satisfied that there is sufficient probable cause as to count one, assault with a dangerous weapon, that will be bound over to the circuit court. Count two, domestic violence, third offense notice, habitual offender, will be bound over. She gave testimony again of an alleged assault, and she was a person that he was allegedly in a dating relationship with and or resident or former resident of his household based on her testimony. Bind over date is going to be November 1st. You do not need to appear in circuit court on November 1st, sir. That's the date that they'll get the file from the district court, okay? Okay. Excuse me?
Whatever.
Okay, he can be remanded. Any additional matters for the record?
Nothing from the people, Your Honor.
No, thank you.
Thank you.
He doesn't know how lucky he is. There's no home invasion first.
I was waiting for it.